for being late. Sadly, I had a little difficulty getting logged on. My name is Emma Brownless. I'm the inspector who's appointed by the Secretary of State to conduct this hearing and to determine the appeal by Kelling Estate LLP. This appeal results from the decision of North Norfolk District Council to refuse planning permission for the erection of 8 dwellings, car parking, associated access and landscaping following the demolition of the existing buildings. We will come to the event management shortly, but I just wanted to say that when you're not involved in the discussion of the event, please mute your microphone and turn your camera off. But when you wish to speak, please turn both back on unless you would prefer not to be seen, and use the raised hand function on your toolbar. I will pause it as we go through to see if anybody has any questions. I have a number of people that I can see along the top of my screen, most of whom have their camera off and microphone off, so thank you. I need to make sure that everybody is here first and can hear me and can be heard. I have a list of people that have been provided to me who are due to be attending the hearing today, so I will just check with everybody to see that everybody is in the hearing. So I have Philip Rosen.
Confirmed, ma'am.
Oh, good, thank you. Kathy Batchelor.
Yes, I'm here. Good morning.
Good. Good morning. Chris Young.
Yes, present and correct.
Good. Mark Ashwell.
Yes, good morning.
Good morning. Isabel McManus.
No, Isabel will now just observe on the YouTube channel.
Wonderful. Okay, thank you. And then I have Councillor Holiday.
Haven't seen her arrive, not yet, no.
Councillor Toy.
No, haven't seen him yet either.
Tina Self, I think I'm speaking to.
Yeah.
And Matthew Stenbrowitz.
Yes, I'm here acting as host, yep.
Thank you. And Lauren Gregory.
Yep, also here acting as co-host.
Just in terms of those host individuals, are you planning on taking part, or are you just here to facilitate the meeting?
We are just facilitating the Zoom aspect of the meeting.
Lovely, thank you. And then for the appellants team, I have Claire Parry.
Yes, madam.
Thank you. Jeff Armstrong.
Morning.
Good morning. Roger Welshman.
Yes, good morning.
Ben Wright.
Good morning, ma'am.
Good morning. And Peter Morgan.
Yes, good morning.
Good morning. That completes my list. Is there anybody who is on here that I have missed out? I can see there are a couple of individuals from the planning inspectorate, Mr. Nash and Mr. Alford. I think they're just here to assist me to make sure that I've managed to get onto the meeting. Just for their information, I can't currently use the camera, so I will be coming to Mr. Alford shortly, but I am in the meeting. But is there anybody else who appears and who wants to take part in the hearing? I can't see that I've missed anybody. Speak now if there is. No. Okay. I can't see that I have any interested parties here today. I note that there were 2 councillors due to attend. If we can just keep our eye out for those, if anybody notices that they pop up on the screen, if you could just let me know, I'd be grateful. So today's hearing will be a structured discussion, which I shall lead based upon an agreed agenda, which was issued ahead of the event. We'll come back to that in due course. And just in terms of the event management today, before we start the discussion, there are a few formalities that I need to complete, and I will outline the procedure for the hearing that I intend to follow. The purpose of the event is to enable all of you to put forward your points of view and to help me get the information I need to make my decision. Whilst much preparation has gone into this digital hearing, it is possible that issues arise that we're not expecting. I'm at 10:15, I'm already at 100% record for those issues. But if for some reason we do hit some technical difficulties, I am concerned to make sure that everybody remains engaged. And I note that it can be much more demanding communicating via video link than in person. I therefore intend to sit for no more than around an hour and a half at a time, and have some regular breaks in between. If anybody needs or feels that an adjournment would be useful at another time, then please do let me know. When we adjourn, please remember to allow me to leave the meeting before you do. I will leave the meeting completely so that I cannot hear or see anything. If you wish to do so, you should be able to stay within the virtual meeting room. However, please do not discuss the detailed matters with each other during this time, as you will remain audible and visible, and I understand this event's being live streamed. So please note that, and obviously if you do wish to discuss things, please mute your microphones and turn off your camera. This is a reasonably small hearing, albeit I think we have 5, 6, 7, 9 individuals who I think wish to take part, along with some individuals facilitating the meeting. I can't see everybody on my screen at once, so please, if you do wish to speak, let me know. I'm sure there's a raised hand feature on here. I'm sure someone will point that out to me if there isn't, but do let me know via that facility. Unlike in a physical event, during the virtual hearing, you can only see my head. Hopefully you'll be able to see my head shortly, and shoulders. Reading body language is harder than in person on these types of hearings. Just to be aware that I may be looking down, and that's probably because I'm taking notes. And I also have a separate screen to my side, so I may be looking at something there too. It doesn't mean that I'm not listening to you. Similarly, if I'm watching you speak, I'm likely to be looking at the image of you on my screen with my eyes cast down rather than into the camera. So please don't think me rude. If anybody suffers any IT problems and loses their connection to the hearing, I will adjourn initially for 5 minutes, and you should attempt to log straight back in the same way that you did for the main event. If matters are not resolved, and that particular part is crucial to the point of where we got to in the hearing, I'll ask the counsel to just take over and liaise with that person to try and get them back on screen. In the unlikely event of major disruption, or it becomes obvious that it's not possible to proceed as a digital event, I will adjourn the hearing, and that my case officer then would contact you as soon as possible to explain the situation and how I wish to proceed. If at any stage anybody is unhappy with the proceedings, then please let me know. As with a physical event, please turn off mobile phones or switch them to silent. If possible, please close your email software to avoid notification sounds, and that will prevent disruption. Does anybody at this stage have any questions or concerns about the technology or the general management of today's event? No, lovely. During the discussion today, I will invite contributions from one side and then the other. And if we have any interested parties present, I'll invite contributions from them as well. Please answer my questions as clearly and concisely as you can. Please be aware that I have read all the written statements, so there's no need to repeat material, although I would ask that you draw my attention to something specific. The This is key given a virtual hearing where timings need to be more controlled. If you want to make a point or you feel that I'm moving on before you have said all you want to, then please let me know. I understand counsel are here on behalf of the appellant. However, there will be no formal cross-examination of one party by the other, and all questions should be directed through me. In terms of notifications of today's hearing, I understand and have received the letter that went from the council on the 4th of March. The letter I have is addressed to the Highways Authority, but it's also accompanied with a work card with all of the parties and third parties. I presume that letter went out to everybody on that list.
Yes, it did. Yeah,
that's lovely. Thank you. And in terms of the last date where we sadly had to postpone the event because of the issues with the unregistered piece of land, I think I'd asked for a notice of today's hearing to be placed in the newspaper, but from my reading of it, it hasn't been. Is that correct?
yes, that's correct.
Okay. In terms of, and this is a question to the appellant, I understand you put a notice into the local press when that issue was raised.
Yes, madam.
Was there anything to come of that notice, or did it generate anybody's interest, or did it fall on silent ears?
Not that we're aware of, madam. It did direct those who wish to make representations to the planning inspectorate, so notifications would have come to PINS, but certainly we're not aware of any
No.
to that.
No, and neither am I. I am concerned because I obviously did ask for that notice to go in the paper, but I think on the back of having the notice go in on the 21st of January, that gave 14 days for a response, and in the absence of any response, I'm not minded to adjourn today's hearing. I think on that basis, I'm happy to proceed. Okay, so in terms of representations, just to let everybody know, I've had copies of those, and I've had regard to those, and will do so in reaching my decision ultimately. In terms of evidence, I do wish to deal with late evidence, but I am just at this moment in time, I'm just going to take sort of a 5-minute break in my opening just to try and resolve this issue with my camera. I can see I have a number of messages popping up on my screen, so I'm just going to adjourn. In fact, I'll adjourn till about half past. I'll just try and resolve this issue with the camera so that everybody can see me. And oh, hello. And then we'll take it from there. So if at this moment in time, if I adjourn till half past, and then I'll come back into the meeting. Thank you. Right, good morning. I am back, but I don't think anybody can see me still. Is that right?
That's correct, Ma'am. Your video is not appearing.
Okay. Well, I am just going to adjourn again and just resolve this issue. I will be back at 10:40. This hearing's adjourned. Do bear with me. My apologies. Right, good morning again. Can everybody hear me and see me?
Yes.
Yes.
Wonderful. That's a result. Thank you for your patience. Right. Okay, let's carry on. So, evidence-wise, all the documents and evidence should already have been provided. I'm not inviting any other evidence, but if you intend to submit anything else, please tell me now. I do have a couple of documents that I do need to deal with that I think have been hanging on from a couple of weeks ago in an email, so we will come to those. But is there anything else that I need to deal with at this stage?
Madam, did you receive the letter that we sent in on Friday about nutrient neutrality?
I have that. We'll deal with that as well. In addition to that letter, is there anything else? I presume not.
No.
The issues that I recall having outstanding are the Aomb management plan and which version essentially I am working from. If there was, I think I asked the parties to see if there was a common agreement to start with. Has there been an agreement on that particular issue?
Madam, I understand that on the website, the 2014 to 2019 version has been temporarily removed. So we evidently need to work with the other version. We can obviously deal with that in the next session, but we don't think it makes any particular difference.
Okay.
Madam, we would agree with that as well. Just to give background for everybody, I'm sorry, I apologise for the confusion on this. There's been some major restructuring at the partnership who manage the Aomb. A draft of the new plan, the 19 to 24 plan, was consulted on, and then it was prematurely published without full ratification by all of the partners. So that's the reason that it's been rescinded.
Right, that makes that.
We are now working to the 14 to 19 management plan.
Right, thank you. And I understand I've been provided with a copy of that 14 to 19 plan, haven't I?
Yes, it's my understanding you have, yes.
Thank you.
And also just to say, there are key issues in there that are common to both plans, like the special qualities of the Aomb.
Yes.
There aren't really any major differences in it. It's just that we are now all working on the published and adopted plan 14 to 19. Thank you.
Thank you. Okay, the other issues I have are there were a couple of applications within the vicinity that I think the appellant was wanting to rely upon. So I think perhaps if we deal with those two first, as I understand it, I've been provided with copies of the officers' reports and the decision notices in respect of them. My understanding was that the council I think had some concerns about that they should have been tied up with the appellant's comments. Okay, there was potentially, they could have been dealt with in the appellant's statement of case. So I'll just, if I perhaps go to Miss Parry, did you wish to speak? And then I have a hand up for Mr. Rosen as well.
Yes, madam. So there's two decisions. There's one at Bacton, which deals with the change of use from a care home to residential, and there's one at Two Oaks, which deals with replacement dwellings in Kelling. Madam, in relation to the Bacton decision, this decision was made on the 1st of October 2021, which was significantly after we put in our evidence on the 5th of August. So we obviously couldn't have put it in with our evidence. It's two things in particular. There's an officer's report and there's an email from an officer as well. And the point in relation to both of them is that CT3 is not mentioned despite a change of use from a care home to a residential. In fact, the officer's email specifically says CT3 wouldn't apply to a care home, which is of course our case. Madam, the other documents relate to Two Oaks, that's in Kelling. I accept that this decision was made before we put in our evidence. We applied to put in this because of the way that the council put their case in their statement of case, and it seemed to us that they were suggesting that in circumstances with reduced facilities, there could never be a permission, whereas that seemed to be inconsistent with the approach they'd taken on an application on the Kelling estate at Two Oaks in Kelling. So that's simply why we put that in. It's in response to the way the council put their case.
Okay. Could I just give the council an opportunity to comment on those, please? Mr. Rosen, did you wish to come back on those?
Briefly, please, Ma'am. Please excuse me today. I have COVID, so my colleagues will be covering the majority of the cases, but I'll be happy to assist and answer questions wherever I can today. In terms of the Bacton case, the council's position is straightforward on this matter. CT3 clearly, in our view, does apply to the particular case here. The appellant's endeavour to prove inconsistencies in approach. When you review the officer's report, you will see that the officer does in fact actually consider CT3 in a roundabout manner. There is no consultation with our planned policy team on this matter. You'll find that the officer's report considers that the position of Bacton in the relation to the loss of this small-scale care home to provide 2 dwellings was considered acceptable on the basis that there was an existing significant element of supply of care home provision within the locality.
Mr. Rosen, can I just interrupt you there, because I suppose the issue that I want to deal with at the moment is whether that should be accepted in evidence. The appellant's argument was that decision post-dated essentially the appellant's statement of case, and therefore it should be accepted as late evidence. So my question to you is, do you accept that's the case, and are you content to do you have any contrary view that it shouldn't be accepted as late evidence, bearing in mind their explanation on that particular one? If I then determine that it can be accepted, then at that juncture and main issues, we will then revert back to it, and you can obviously give the council's account of that particular development. But just for today, for this moment's purposes, it's whether you have any strong feelings as to whether I should.
The council will accept the submission. That's accepted, and we will speak as advised.
Is that the same for the second development, the Two Oaks case?
Well, the appellants speak of the way in which the council articulates its case. The Two Oaks case is known by the appellants team for some significant time. It was proposed as part of the wider estate master plan. Again, the council will accept the submission of the late evidence, but it is frustrating that a known case such as Two Oaks was not considered alongside the elements and the submissions made to the inspectorate, and these made so late in the day. Thank you.
Mr. Rosen, that's very helpful. I think with those comments in mind, I am minded to accept both of those as late evidence, and at some appropriate juncture today, when we get to that particular main issue, I'd like to hear from the appellant and then the council as well, if that's you, Mr. Rosen. So I will accept those 2 particular items. And then the last item I think I have is the nutrient neutrality letter. I don't know whether you wish to explain that particular bit of evidence. As I understand it, that came in, it's a letter as of last week's date. But if you, Ms. Parry, if you wish to explain that particular late evidence, why it's late.
Yes, madam. I'm sure you're probably familiar with the nutrient neutrality issue. There was a significant announcement, I believe, last Thursday, in that there was an extension of the local authorities to which the nutrient neutrality guidance referred to. So evidently, given that that announcement was only made last Thursday, we couldn't possibly have put this evidence in any earlier. It wasn't known to us before that date. It is significant and important evidence because, as accepted in the Chief Planning Officer's letter that accompanies it, it's evidently going to have an impact on housing delivery and housing supply. So we suggest it is important evidence, and we couldn't possibly have put it in any earlier than we did.
Thank you. Mr. Rosen or anybody else on behalf of the council, do you wish to come back on that particular point? Mr. Rosen?
Thank you, Ma'am. Absolutely understood. This is an issue that arrived on Thursday lunchtime with the council and with the appellants, so it is an issue that should be reviewed. Clearly, the appellant has submitted a comprehensive written submission. The council's position on this issue is one that we would wish to make written representations formally to the inspectorate to assist decision making. The extent to which we can draw lines on housing, land supply, etc., through our district on the basis of an English nature submission made on Thursday for you today is obviously limited. Our concerns are that we have a district-wide position to address here for nutrient neutrality, and that we need to address that in a formal and consistent way across the district, rather than doing it in an ad hoc way in a hearing today. Thank you.
Thank you. Well, in light of those, I'm minded to accept that document as late evidence. We will obviously come back to that particular point, and in the meantime I'll have a think about how potentially we deal with that, and I'll take account of people's views at that moment in time. Obviously Mr. Rosen is suggesting he would prefer to deal with it by way of written representations, and we'll come back to that particular point unless anybody, Ms. Parry, if you wish to say anything on that point now.
Well, Madam, I think we have concerns about written representation because it's obviously going to prolong the matter. It's a fairly straightforward question when we look at the 5-year housing land supply. Are these sites inside or outside the zone? But we can obviously see how we get on in the 5-year housing land supply session, and if that becomes problematic, we can come back to it.
Lovely, thank you. Well, as I said, I'll accept that as late evidence, and we'll return to that particular item to see how we deal with that in due course when we come back to 5-year housing land supply. Okay, in terms of evidence, is there anything else that I need to address? No? Okay, I'll move on to plans then. Helpfully, the plans fall within the agreed statement of common ground. So I won't propose to go through those individually as they're listed there and they've been agreed by the parties. Can I just double check that there are no further plans that I need to take into account? No, okay. Thank you. Moving on to site visit as a procedural matter, just to let you know that I have already visited the appeal site recently when I was in the area and viewed it from the public domain, albeit briefly, just to get a general awareness of the site in the area. It's often very difficult to deal with hearings if you don't have a basic appreciation of what you're dealing with. So I have seen it, albeit briefly. I will arrange a site visit after I've heard all of the evidence, and I intend to carry out this site visit unaccompanied, unless there are any views to the contrary, but we can deal with that later on in the hearing. In terms of conditions, there's a space on the agenda to discuss what conditions might be appropriate where I am minded to allow the appeal. This is standard procedure. It does not indicate that I've made up my mind on this case, and nor will it affect the council's position in relation to the proposal. Helpfully, the council have provided, as part of the statement of common ground, the conditions, And I have had an update of those conditions with the reasoning for those conditions being put forward. And I hope the appellants had a chance to see that. And I'll just double check, are there any issues arising from those additional reasoning that have been added?
No, Madam, thank you.
Thank you.
To be clear, ma'am, the conditions reasoning was added by the appellants, and the councillor content with the reasoning that has been given. Thank you. Just put that one the right way around. Thank you.
Lovely, thank you. That's very helpful. Costs, I don't have any written costs application that have been submitted to me at this time. However, I do have the power to initiate an award of costs in addition to any application that may be made verbally today at the hearing. If anybody wishes to make a cost application, just to please do make me aware. Now might be a good time, but obviously it may well be something that arises during the hearing. So there is space on the agenda for those matters to be considered in due course. Is anybody planning on making a cost application that they know of right now, or?
None's to be made on behalf of the council, ma'am.
Okay, thank you. And the appellant?
Same to the appellants, Madam, none at the moment.
Right, thank you. In terms of the procedural side of things, does anybody have any questions regarding the hearing and how it will be carried out? No? Okay. So just setting aside the procedural matters, I do have a few preliminary matters just to make everybody aware. I do have, as I've said, a statement of common ground signed by the appellant and the council, and then I have a separate statement of common ground regarding 5-year housing land supply. So I do have both of those. I also have a section 106 unilateral undertaking together with manuscript amendments. I understand that that unilateral undertaking is acceptable to the council. Is that right, Mr. Rosen?
Agreed, ma'am. Yes, it is. It's drafted and satisfies the council's concerns on GRAMs.
Thank you. And just in respect of the statement of common ground, I note that the council do not wish to contest that part of their reason for refusal that concerns ecology and biodiversity. Is that correct?
Correct. That's on the basis of the acceptance of the unilateral undertaking.
Thank you. And as I've mentioned, there is a draft list of conditions. I presume that's all up to date. If it's not up to date, can you please ensure that I do have an updated list before we discuss matters relating to conditions? Does anyone wish to add anything on preliminary matters? No? Okay. Just turning to development plan policy. Again, the statement of common ground confirms that I'm to have regard to the North Norfolk core strategy incorporating development control policies of 2008 and the site allocations plan of 2011. And in particular, I note that policies SS1, SS2, EN1, EN2, EN4 and CT3 are all relevant to this appeal and cited within the reason for refusal. Are these, am I right that these are the main ones that I need to consider, or have I missed any of that list?
Yes, Madam, that's correct.
Thank you. And in terms of the level of weight that I should afford the development plan, I'm right in thinking that the parties aren't agreed on that particular matter, aren't I?
If I can defer to my colleague Mark Ashwell on this, Mel.
Yes, Mr. Ashwell.
Yes, so as I understand it, the appellant's position would be that you should set aside the policies of the development plan 5-year reasons. I don't think there's any substantive argument about the relevance of the policies and the fact that the policies are up to date and adopted, but they're asking you to set it aside because the plan is dated for 5-year land supply.
Thank you, Mr. Ashwell. Ms. Parry, did you wish to come back on that? Just to
Madam, that isn't obviously quite how we would put our case. You'll see from my statement that in relation to SS1 and SS2, we have concerns about the extent to which that's consistent with the framework. We have the other policies we say aren't in any event breached. Plus, we say there's no 5-year housing land supply, which will cause a reduced weight on those policies in any event. So.
Thank you. And that there is reference within the statement of common ground to the first draft local plan part 1. Is there any update or change to this? And if so, does that affect the weight that I'm to give to it? I note that the statement of common ground, the parties have agreed that it's at a relatively early stage and accordingly attracts a limit of weight. Is that still the position today? Mr. Ashwell, do you?
Yes, sorry. Yeah. So the only material changes we've just our regular consultation, so stages, but it's an argument that you should be attaching weight to the emerging policies.
Can I just stop you, Mr. Ashwell? Is everybody else having difficulties hearing Mr. Ashwell, or is that just my? Is it just my internet, or is it everybody else?
No,
Ma'am, if I could suggest, Ma'am, that maybe Mr. Ashwell presents for this moment in time without video and
yes,
speaks.
That might help. I just wanted to be certain it's not just me that's causing the technical problems. But Mr. Ashwell, if you perhaps turn your camera off, I'm happy that you're not on screen as you talk. But let's see if you want to start again. I didn't catch anything that you actually mentioned there. It was all very disjointed. So if you wish to start again, Mr. Ashwell, I'd be grateful.
Okay, so my video is now off, so hopefully that will improve things. So the only material changes, we've completed the Regulation 9 consultation stage now. Consultation closed a couple of weeks ago, so that is another formal step, if you like, in the plan making process. But we're not going to suggest that you attach.
Oh, Mr. Ashwell, I've lost you again. Has everybody else lost Mr. Ashwell?
We have, Ma'am. Let me complete that. We can deal with this relatively simply, Ma'am, to enable us to progress. We would not ask for significant weight to be attached to the emerging plan policies. Let's move forward.
So it remains as in the statement of common ground that it should attract limited weight as far as the council can.
It should, Ma'am. We've moved to consultation, so that there's perhaps arguably a small scintilla of greater weight, but we haven't reported to working party, and clearly we need to progress beyond that point. It should be given limited weight.
Thank you. Ms. Parry, did you wish to come back on that point?
No, Madam, our position remains as set out in the statement of common ground.
Thank you. And then there is reference to the emerging draft North Norfolk design guide. Is that still an emerging document? Or am I to treat it as part of the development plan? Or
perhaps we could try to take Mr. Ashwell again. If he's unable to attend, then I will step in.
Mr. Ashwell, are you there?
Can you?
It is a little bit disjointed. Do try, Mr. Ashwell, and if not, I might have to.
It's still an emerging draft SPD, so it's not formally part of the development plan.
Thank you. Does the appellant wish to come back on that?
Madam, we obviously accept it's not formally adopted. It is useful guidance that has been set out, I think, for quite some time as to what the council consider acceptable in design. And as we've explained, we follow the principles in it.
Thank you. Right, is there anything else that I need to have regard to any of the policies that I've not mentioned already? Or does anybody have anything relevant to add about policy at this stage?
Nothing further to add on behalf of the council.
Thank you.
Not from us, thank you, Madam.
Thank you. Okay, so at this point, I'm going to move on to the main issues for discussion. Unless anybody has any suggestions, I propose to take them in the order on the agenda. Starting with the first one being whether the appeal site would be an appropriate location for the proposed development, having regards to policies for the location of new housing and its accessibility to services and facilities. I propose to start with that one, and then once we have done that one, we'll take a short break just to give everybody a break from the screen. So as I've already mentioned, I have read everybody's arguments on those particular matters. I don't have many questions, but I just wonder whether the parties just wish to go through and sort of briefly outline their position on that particular matter. Perhaps if I start with the appellant and then revert to the council in due course. All I would ask is that you don't repeat all the evidence verbatim. I obviously have it in front of me.
Thank you, ma'am. If I just perhaps highlight some of the key points, as you say, rather than go through the evidence in massive detail. I think the key issue here, the area I would like to highlight, is the fact that we are talking about a brownfield site. We are talking about a site which was last used as a care home. Before that, it was used as a hotel. Both those units, both of those uses generated traffic movements, pedestrian movements, cycle movements. So we're not talking about a greenfield site. And I think, certainly reading some of the council's evidence, that's the feeling I get, is that's where they are comparing us to. I think, again, if I can refer you to the highway authority's comments as well, which have been clarified in the council's evidence as a no objection. There is lots of commentary about the site and sustainability matters, but ultimately the highway authority are not objecting. And I think that's a key consideration as well on the issue of accessibility. We also have the advice as set out in the MPPF, and I'll just give you the paragraph 79 and 105, where we all have to treat rural areas in a different way to urban areas in terms of sustainability. And that's, again, ma'am, is if you refer to the appeal decision which we've submitted for the site in Bristol. That was from November 2021. Again, there is a section under accessibility. And again, without reading them out, there is an acknowledgement by the inspector at this appeal that it's not unusual for there not to be dedicated footpaths or street lighting in village locations, acknowledging that bus services are going to be less frequent and there will be a greater dependency upon car use in rural locations. So in terms of comparing apples with apples, I think the rural locations have to be treated as a separate entity. The other issue I'd like to raise is what this sets this site apart from other sites is the proximity to the garden centre. Now, we obviously have the luxury of working for a landowner who owns large areas of land in this location, and is planning, has plans which look at how these uses might work together, how they might connect together. And to that extent, we have produced a master plan, Madam, which I would just ask you to have a look at it. It is a little bit outdated now, but it shows the intent of the landowner to look at his whole estate and try and look at connectivity and management wherever possible. When we were looking at residential use of this site, the work was ongoing for the garden centre, and obviously when you have your site visit, you can go and have a look at the garden centre, so I don't want to go over that in massive detail today, but what you'll see in the garden centre is I guess you could say the equivalent of a village shop. I would suggest perhaps even more. There is a food centre in there, there is refrigeration selling food, there is clothes, there's a cafe, there's a play area, and more. And so very much as you see in garden centres these days, they offer more than just plants and tubs these days. They offer the full suite of offer, if you like, which people expect. So we're going to be providing a dedicated link from this site to the garden centre, which means that the residents living there will be able to make use of all of those facilities there. Now the council have suggested that that is not a significant consideration in this instance, but I think inevitably it has to be, and has been designed to be complementary to our scheme and the wider area as well. So I would certainly say it's a game changer, for want of a better phrase, and one which I think should be given significant weight when you're considering these particular issues, Madam. A point I think just worth making briefly is that supermarket deliveries are frequent and common in this location. I know this is a point which our client wanted to be made, in the sense that there were areas of the country not that long ago where you couldn't get deliveries from all of the supermarkets. You can actually now get pretty much a delivery from any supermarket in this location. Now, how does that aid sustainability? Well, it just means that there will be deliveries for up to a dozen houses on one lorry, and that lorry will then reduce the overall carbon footprint and the amount of traffic which is on the road. So it's something which the supermarkets have now become far better skilled at, and these houses will benefit from this service as well. I just wanted to raise briefly the issue of cycle provision. We have looked at that in some detail, and in my evidence, I'll give you the reference 643 onwards, Madam, you'll see that we set out distances which all fall within the 5 kilometre distance, which is set by Manual for Streets as being a reasonable distance for people to cycle to make use of facilities. So as you can see, there are an awful lot of properties. I mean, Holt, Weyburn, and High Kelling are all within the distance as set by within the 5 kilometre distance. There's obviously informal and formal cycling routes for people to make use of, and that's one of the attractive facilities which people move into this area for. And I don't think, again, from a highway safety point of view, cyclists using the roads, I mean, the advice we've had from our highway consultant, and again, it wasn't an issue for refusal from the Highway Authority, is that rural roads which produce less than 100 vehicles an hour, which is, in this instance, is the case, village roads in that situation very much act as shared surfaces as they would in urban areas. So I think it's not uncommon when you're driving rural roads anywhere, not just in this location, for there to be cyclists using the road, both your professional and also your less than professional cyclists. So it's not, I think we're suggesting something which is uncommon. for cyclists to make use of the roads as they are at the moment. Clearly, pedestrian movements, walking is going to be slightly more challenging, but there are still footpaths available, and there's opportunity for walking within the road itself. The same would apply for people walking in the rural roads as it does people cycling in the rural roads. Again, final point, Madam, is people have a choice when they buy these houses. People will be buying these houses in full knowledge of their location. They are set in a rural location. Mark doing this job for quite a few years now, and it is absolutely common sense that people will choose to live in an environment which suits them. And these houses will be, I'm almost certain, will be occupied by people who appreciate their rural location and where facilities are and how to get to those facilities. So I understand the issues which the council have put forward, but I think in this instance, given the proximity of the garden centre, the flexibility which sustainability needs to be treated in rural locations, I believe that this is a sustainable location and that the council's concerns will should be set aside accordingly.
Thank you. Can I just ask just a couple of questions on that? In terms of, you set out the range of goods at the garden centre there. Is it the appellant's evidence? And obviously I will visit, so I'll be able to have a look for myself. But just so I'm clear at this moment in time, it's the appellant's case that there are some goods within that garden centre that would meet daily needs. So you mentioned this refrigeration and likes. Is that, have I misinterpreted that, or is that your case?
That is the case, Madam. There is, when you walk, you'll see when you are leaving the garden centre, there is a fairly large food area which you can buy general everyday goods there, pasta, bread, milk, etc., with refrigeration there as well. So you can buy effectively everyday goods from in that garden centre. It was done more informally through the cafe until recently, but part of the plan of our client was to establish something more formal within the garden centre, because it's something which has been proved to be quite popular with people already visiting.
And just in terms of the distances on bicycle, I think there's some suggestion it's around 2.5 kilometres. This question's a little bit loaded because obviously it depends on everybody's ability on the bike. But what sort of time frame are we looking at travelling on a bicycle to access those facilities in Holt and Kelling?
I think it would. Yeah, I mean, it's a tricky one given people's ability to do it. But I would say maybe 15. If you're taking a leisurely ride, if you didn't have all the lycra and had a professional bike, I think you'd be talking about 15 minutes, that sort of time.
Thank you. If I can then perhaps invite the council to just come back on those particular issues. Mr. Ashwell, are you?
Yes, can I just see if that works with my video on to start with or not? Is that relatively clear?
It seems to be. If we start to lose you, I'll let you know, and we might have to revert back to. I
just like to have a presence on the screen when I'm talking. To be honest with you.
I know. I felt the same earlier.
Yeah. So I think the starting position for the council would be to put the policies in their right place in terms of the decision-making process. And I noticed that the appellant describes their proposals as a technical breach of policy. And I see that phrase appearing on behalf of appellants up and down the country as if there's some sort of minor technical breach going on here. That's clearly not the case. Policies SS1 and SS2 are absolutely fundamental to the way that the strategy, the spatial distribution of development in the district works. They give effect to how the council intends to distribute housing growth and other growth across North Norfolk. And the proposal clearly doesn't comply with that. That's accepted by both parties. We both recognise the sites in the countryside, and we both recognise that housing development in the countryside is a departure from policy. And we would say it was a fundamental departure from policy, not some sort of minor technical breach. And the appellant asks you to set that aside on the basis that the site is a brownfield site. It's been previously developed. And the first point to make is the fact that the site is a brownfield site is not one of the forms of development which is permitted in the policy itself. So in the bullet points in policy SS2, which lists the acceptable forms of development in countryside locations, one of those bullet points is not that the site is previously developed or brownfield. So that doesn't make the proposal policy compliant, nor is there such a presumption in favour of brownfield development in the countryside in the MPPF, which rightly gives priority to development of brownfield and previously developed sites, but those sites which are otherwise located in sustainable locations. So the notion that just because it's a brownfield site means that you can set aside the broader principles of sustainability is clearly wrong as a starting position. I listened carefully to what was said about, well, that doesn't matter because there's a garden centre next door. The location is sustainable because of the range of products which are available in the garden centre. And that was based on the ability to purchase some convenience goods shopping, loads of bread and pasta and chilled goods. When I visited the garden centre recently, there certainly wasn't a school there. There wasn't a veterinary surgery there. There was very limited employment opportunities. There wasn't a sports centre. All of the services that you would normally expect to access as a resident of a property are distant from this site, at least 2.5 kilometres away, and in relation to higher order services, very, very distant from this site. Certainly not going to get on my bike and walk into Holt to go to the doctors or to access a job further afield in Fakenham or Cromer or Norwich. I'm going to get in my car and I'm going to drive. And there's no doubt in my mind that the residents in these properties will essentially do the majority of their day-to-day travelling for multiple reasons in motor cars. Some might exercise the choice as it was described. People who live in these sort of locations exercise choices. Some might exercise the choice to get on their bike and travel into Holt or elsewhere, primarily I would suggest for recreational purposes. But the notion that on a day-to-day basis, people will walk or cycle from this location to access the things which they need, I don't think stands up to any sensible scrutiny. So our position is, and always has been, that the site is an entirely unsustainable location for development. And whether it's brownfield or greenfield, it doesn't affect that basic proposition that residential development here would be unsustainable.
Can I just press you on the point that was raised at the outset, which was in regards to the use of the site as its previous use would have generated traffic, pedestrians, cycles. Did you wish to come back on that at all, Mr. Ashwell?
It may have, and then you'll be considering whether you're going to attach any weight to the fallback position around reuse of the existing building for its previous purpose. My understanding of the appellant's position is they've got no desire to return the building to its previous purpose. They want to demolish it. So I don't think there's any realistic expectation of that fallback position actually materialising on the ground. The stated intention of the applicant is to demolish the building and develop the site for something else. The building was historically used for a purpose which complied with policy and provided some useful benefits locally in terms of the housing that it provided. and some minimal local employment opportunities. That's not the same with housing development.
Thank you. Okay, did anybody wish to mention anything else on that particular matter?
Can I come back, Mum, on a couple of points?
Yes, you can.
Thank you. Listening to what Mr. Ashwell says, clearly that the Highway Authority in their consultation response have taken a slightly different view to him, in the sense that they've acknowledged that there is a use on there, and that use generated traffic, and it was on that basis that they haven't raised an objection, and I think that is the correct way to deal with it. Exactly what happens to that site, whether the building goes or stays, it's generated traffic in the past and it'll generate traffic in the future. So I think that's a really important point to take account of. Mr. Ashwell has applauded policy SS1 and 2, and I can understand why he would do that. The point I wanted to make is really on the brownfield site side, and how I believe they are both out of kilter with the NPPF. I mean, the first SS1 has no reference at all to brownfield sites. It doesn't recognise them, and I mean that's Mr. Ashwell has just confirmed that. And yet, if you look at paragraph 119 of the NPPF, that makes quite clear the priority that brownfield sites would have, and it doesn't say that brownfield sites only in urban locations. It just says brownfield sites. So again, SS1 is out of kilter with the NPPF, as is SS2, although it's marginally better. It does allow it in the fourth bullet point for the reuse and adaptation of buildings for appropriate uses. It says nothing about redevelopment. So the way Mr. Ashwell reads it, if we're not on the list, it doesn't happen. Yet the NPPF doesn't set that limit. It talks about best use of brownfield site, which might be redevelopment, it might be reuse, could be a whole range of issues. So I think on both instances, and that's the main point we're taking on those policies, is that they are out of kilter with the NPPF, and that's why our scheme, whilst being a technical breach, that breach is resulting because the policies in themselves are not up to date.
Madam, if I could just deal very quickly with the technical breach point. The point that the appellant's making here is when one looks at SS2 and development in the countryside, it does allow certain types of reuse in the countryside. For example, the reuse and adaptation of buildings for appropriate purposes and the extension and replacement of dwellings. And although we accept we don't strictly fall within either of those categories, what we would say is what we're doing is analogous to that. And therefore, we are not within the letter of the policy, we're within the spirit of the policy. And it is, therefore, we say, a minor breach of the policy, which is going to carry less weight than a fundamental breach of the policy in the way Mr. Ashwell outlined it.
Thank you. Mr. Ashwell, did you wish to raise any?
Very, very briefly, I think what I heard there was that because the policies allow for the conversion of existing buildings, they should allow for the erection of new buildings because that's an analogous form of development, a similar form of development. And clearly the policy is not drafted in that way. It specifically is drafted to avoid housing development, new build housing development in the countryside, and allow for those forms of development that make good use of existing buildings and the other things which are listed as exceptions and reasons why you should build in a rural location. On the Highway Authority comments, I think what the appellant's doing there is conflating technical highway comments about capacity, comparing traffic generation from the former use with traffic generation with the proposed use and concluding that it may not be dissimilar, is saying nothing about the sustainability of the location. The Highway Authority are commenting on the technical ability of the network to accommodate the likely traffic associated with the development proposal. and concluding on those narrow technical grounds they won't raise a highway objection. They're not saying, and it's not their role to say it, is whether this location is a sustainable location for development and likely to be dependent upon car movements in order for people to meet their day-to-day needs. That's a matter for the planning authority to determine.
Thank you. Does anybody else wish to raise anything on that particular main issue? I know that Councillor Toy, you're in on the meeting at the moment. I don't think you were there at the outset, but if you do wish to take part and have your say, just raise your hand using the hand function, and I can come to you. Does anyone wish to say anything on that particular main issue? Nothing further? Okay. I'll just double check whether I had anything else I wish to ask. Well, just I suppose just a query in terms of, there is an emerging local plan as far as I'm aware, where policies SS1 and SS2 have been argued to not specifically align with the framework. What sort of the movement within the emerging local plan? Is it following the same format as SS1 and SS2 at the moment, or is there any change in light of the framework and its provisions on brownfield sites?
Okay, so there's no specific change on the brownfield site issue. So the new plan doesn't include a policy which allows for the development of brownfield sites in the countryside policy area per se. There is an adjustment to the settlement hierarchy in the broad patterns of distribution of growth. So although largely speaking, we intend to distribute development into the larger settlements, as you would expect us to, at the lower end of the settlement hierarchy, there's a wider range of smaller villages where we will be adopting, if the plan gets through examination, a slightly more flexible approach to rural housing. And that's in response to the MPPF's encouragement to assist with the vitality and viability of rural settlements. So this notion that the current core strategy and a number of local plans are too restrictive in the countryside has been reflected upon as something which will feature in the new plan, that we are looking to select a wider number of settlements and allow for relatively modest small scales of growth in order to assist with the rural vitality and viability of rural communities. The principle, that won't change the planning status of this particular site, so it's not a major shift. Sort of settlements, you won't be familiar with these, Mum, but they're settlements with schools and shops and other modest services now come into the settlement hierarchy, whereas under the current core strategy, some of them are excluded in appropriate locations for development.
Thank you, Mr. Ashworth.
A slight tweak, a slightly more permissive approach, but not to the extent that development in the rural area outside of adopted development boundaries will suddenly become acceptable.
Thank you, that's helpful.
Madam, just for your note, we have put in a Regulation 19 response to the plan, raising concerns about the approach taken along the lines that we've already outlined to you about the existing plan.
Thank you. Anybody else wish to say anything on that particular main issue? Okay. Well, I am going to stop there for a brief break, after which we'll move on to the second main issue item regarding character and appearance and landscape matters. But if I take a 15-minute break there, and if we return at 11:50, so this hearing is adjourned. I will come out of the hearing now and try and reconnect in a little while. So 11:50, this hearing is adjourned until. Thank you. Okay, welcome back everybody. Can I just double check everybody can hear me?
Yes, thank you.
Lovely, thank you.
Yep.
Okay, so agenda item, main issue number 2. The effect of the proposed development on the character and appearance of the surrounding area and the landscape character of North Norfolk, area of outstanding natural beauty. I have rolled up 2 issues really into one main issue there, but I am happy to break them down and deal with them individually, as I know different people will be wanting to speak about different aspects of that. Just in terms of that particular main issue, I've had a regard to the evidence provided, in particular the landscape visual impact assessment. I think from my point of view, for this main issue, I'd like to sort of again offer the appellant the opportunity to just draw my attention to parts of the evidence that they wish me to have account of, and then to revert back to the council to so that I can properly sort of drill down and press the council on where they disagree with the appellant on that particular main issue. So if I can invite the appellant's team to just draw my attention to the relevant evidence they wish to just put forward on this main issue before I revert to the council.
Certainly, Mum. Before that, would you like a little bit of housekeeping? Mum, I'm sure you've realised that the landscape assessment and hearing statement was authored by James Morton.
Yes.
Unfortunately, he apologised, obviously, that he can't attend. But just to confirm that I worked with James, and all the assessment I pulled square behind what is in front of you, Mum.
That's helpful, thank you.
Would you also need my qualifications and experience, or happy to?
Could I ask that you put those on an email and send that in, and then I can note that on the attendance form, and that goes for anybody who wishes to have their particular details recorded. But if you wish to do that, that would be helpful. Thank you.
That's very helpful. Thank you, Mum. Mum, just to save time, do you think I could ask that you have the landscape assessment and the landscape hearing statement appendices?
Yes.
And also the DAS, Mum, please.
Right. Forgive me a moment. When I had technical difficulties this morning, I had to shut everything down. So I have some in hard copy and some I'll just need to revert to.
I mean, it might be, Mum, if it assists, that you just have the landscape hearing statement.
I have that hard copy in front of me.
And also the DAS.
Yes.
Mum, again, I'm very happy to break this down to landscape character and then come back to visuals, or I can continue on.
That would be helpful. That would be my preference.
Certainly, that's fine. So, Mum, just to give you an overview of landscape matters, if I could ask you to go to page 7 of the DAS, page 7. And that is an aerial of the appeal.
Just 1 second, sorry. And that was page 7, was it?
That's great. It's an aerial, red line, just identifying the various components of the appeal site.
Right, got that in front of me.
Clearly, Mum, it's brownfield site. To the centre, the 2.5-storey built form, a considerably large footprint. Mum, you'll note extensive glazing and roof lights. Also, Mum, the exterior hard standing,
is clearly a fundamental part of the site. Similarly, Mum, the manicured lawn to the southern areas. Mum, also along that southern boundary, there's a substantial beech hedge. And you'll also note, Mum, that there is further regenerating vegetation beyond that southern boundary. Alongside that, Mum, you have horticulture further to the south and the substantial woodland to the right of that view, which is to the west. Clearly, Mum, it is a brownfield site that has become derelict, and I'm sure on your site visit you'll note that the various exterior elements of it are becoming rank grassland and regeneration. So, Mark, if I could then ask you to go 6 pages further within the DAS, and that again is another aerial. The title page is actually on the left-hand side in the corner, quite small text, but it's constraints and opportunities.
Yes.
Great. Now, again, Mom, noting the extensive areas that Mr. Armstrong was notifying, the extended garden centre is a substantial footprint. Similarly, extensive car parking and storage areas, which contribute to a busy and active localised character.
Thank you.
Moving on to reason for refusal 1, conserving and enhancing the special qualities of the Aomb. I'd like firstly to remind you that parish have not objected. Similarly, Mom, neither have the Norfolk Coast Partnership. Now, if I could take you to the hearing statement.
Yes.
Paragraph 525. And it's the last sentence. This is confirmed, talking about the highly contained nature of the site within the NCP consultation response, which identifies the relatively well-screened character of the application site. So there's general agreement, Ma'am, that the site is well contained visually. So if I could, Ma'am, if I could then take you to the following paragraph, 526. And again, last sentence, Ma'am. It refers to, sorry, let's get to the, it's actually quite a long sentence. The immediate crucial setting is characterised by the presence of the neighbourhood Holt Garden Centre, which has undergone significant recent refurbishment, increasing the overall extent and scale of the properties and the adjacent State Pit plantation, both of which dominate the skyline and immediate visual environment, noting NCP's consultation response, which refers to these features, amongst others, within the high locality as features which erode the otherwise wild character of the area. And as such, the site is considered to be located in an area of reduced visual sensitivity. Quite a long sentence, that. Ma'am, sorry, I apologise, but I think that was the point.
Can I just clarify, just looking at page 13 of the design and access statement, the picture I'm looking at there, the one you referred me to,
Yes, ma'am.
am I right in thinking that that's the extended footprint of the garden centre? That's, so when I turn up at my site visit, that's what I will see. That's not the pre-extended version, is it, in the design and access statement?
Ma'am, I'll just
that's the new one, isn't it?
the council might be able to assist on this one, maybe.
Okay. Do we know? No, I think it's as it was, not as it was.
Mark, I believe, and we'll clarify this, but it is the previous footprint, so it's not the extended.
Obviously, I will have a good look at the site, but it's just helpful to have that in my mind now. But that's the previous one. Sorry to interrupt you.
That is absolutely fine. Mark, if I just take you to page 37, and that's paragraph 521.
Yes.
So again, it's the North Coast Partnership reinforces that they haven't objected, but within the officer's report, they state that, and in italics there needs to be absolute certainty about the development will conserve and enhance the Aomb. The NCP referred to two of the special qualities associated with the Aomb as being amber, cause of concern relating to one, sense of remoteness, tranquility, and wildness. Now, I'm sure when you visit the sites, you're aware of a lot of activity at the garden centre. It is not remote, certainly not tranquil, and it certainly doesn't characterise the wildness of the Aomb that lies further to the north and east. It does not resemble any of those qualities. Similarly, two, integrity of landscape, seascape, and settlement character. Again, Ma'am, I'm sure on your initial site visit, one of the qualities was views towards the coast. Clearly, there is no views within the locality. So again, those amber concerns can all be ticked. If I can then just take you to assessments, you may have noted that I've considered the effects upon the wider landscape character areas and the Aomb, and that's at JM4 table, and that's page 24 now. And noting you've read various documents. I don't want to go through those, but just to confirm that the assessment of compliance on the right-hand side, Mark, you'll note that either it's not applicable or the proposals are compliant. Similarly, Mark, a further table, JM5, and that's page 29 on. And that table 29 to page 33 considers the effects on the Aomb. And again, Mark, I don't wish to go through it, but you'll note on the right-hand side various enhance, conserve, continues, and there are some areas which are applicable, but the bottom line, Mum, is that we conserve and enhance those particular issues. And then I'm going to effects upon the localised setting, including the site, and that is paragraph 516. And that is page 36 now.
Thank you.
You'll note that demolishing a derelict a large footprint building, improving the built form, reducing the ridge height, providing a sustainable grouping of built form, in addition to extensive landscape improvements, providing moderate/minor to minor beneficial significance. This is noting that there are no characteristics within the site or locality that are similar to the landscape characteristics of those of the landscape type and the Aomb. Similarly, with the wider landscape area, the landscape character area and Aomb, and that's at paragraph 19, just over the page. Sorry, that's page 30. I think it is page 30. Sorry, thank you. Sorry, it's 519. You'll note, because of the lack of visibility, the lack of characteristics that are shared between the appeal site and the wider setting, there'll be a negligible but neutral significance, i.e. one that neither adds nor detracts from the character and quality of that area. In terms of this session, I would conclude that both tables clearly demonstrate that the qualities are conserved and enhanced in both the landscape character types and the Aomb. And I just note that in order to provide a transparent assessment, I haven't seen anything from council that may be in front of you to assess such effects. Just a couple of minor points on landscape character. You'll note that the southern hedgerow beach is agreed that it heavily contains views both within and towards. I believe the council consider that this is this reduces the integration of the site to the wider setting. Mum, if I can take you to page 50, that's paragraph 541.
Page 50.
That's correct, right at the top, Mum.
Thank you. Oh yes, 541.
This is in relation to the Adopted Design Code 2008. I'll just take you to the underlined quote. Indeed, where established hedges and mature trees already exist, they should be retained to provide buildings with a natural link to their surroundings. By preserving a sense of continuity in this way, new developments are also more likely to be accepted locally. Mum, we're not trying to screen a development, we're trying to integrate using the existing boundary treatment. And Mum, also finally, the landscape design within the appeal site can use the types of species that are found in peatland but again, clearly that can be conditioned. That's all I had on the landscape model.
If I can then perhaps stop you at that point and revert to the council just for their comments in relation to what you've already raised. I'm just thinking, is it Ms. Batchelor that's wishing to speak on behalf of the council on this point?
That's
yes.
Mark.
Yeah.
Thank you.
Okay, thank you very much. Just one thing to say, in the main issues we're discussing, I have a colleague, Chris Young, who'd like to make some comments on actual design matters.
Yes.
Maybe that might be appropriate after I
think so. I think, as I said, I've rolled up two issues into one there, and
yeah.
It's easier to separate them back down, in all fairness. So if we deal with the landscape issues then and design afterwards, and you know,
okay, thank you. That's great. Yeah. So if that's all right, I'd just like to share my screen, just show you one plan, really, just to give context while I'm speaking. So I'll just attempt to share my screen. Is that working? Are you able to see that yet? Yes.
Is this a plan that forms part? It looks familiar. I presume it forms part of.
It's basically what I'm just wanting to show is the different landscape character types in the district, and it's directly from the landscape character assessment, the North Norfolk landscape character assessment.
Right. Okay.
So, the blue blob shows the location of the site, and it's within the rolling heath and arable landscape type. That's as defined in the North Norfolk Landscape Character Assessment, SPD, and also in the Norfolk Coast Aomb Integrated Landscape Character Guidance. The site lies wholly within this landscape type, the rolling heath and arable. So it's this pink and the orangey colour on the map.
Yes.
Dissected into two parts. The blue line running through is one of the river valley landscape types. So this landscape type lies wholly within the Norfolk Coast Aomb. The boundary is essentially the site where I'm putting my cursor now. And this is a feature landscape of the Aomb designation. It's typically an elevated open landscape with a strong coastal influence. And it's particularly noted for this, the lowland heath, which is a priority habitat. There are blocks of woodland and an arable land use with very little settlement inland from the coast. And then I'd just like to talk about some of the key characteristics of this type, which are relevant to this site. So I won't go through all of them, but are relevant to this case. One of them being, it's defined as a strong rural character. And this is largely due to the concentration of settlement in villages along the coast, namely Blakeney, Cley and Salthouse. And then a small amount of settlement inland in the village of Kelling. And this lack of settlement leads to dark night skies and quite a distinctive dark nocturnal character. And that's recognised by the fact that within this landscape type, we've got two national dark sky discovery sites. at Wiverton Downs and also at Kelling Heath, which is a kilometre southeast of the site. The Aomb landscape character guidance talks about, as has already been mentioned, the wild, undeveloped character of this landscape type. And that really, they say, is a consequence of the lack of development outside the clustered settlements. They do, as has already been mentioned, highlight that the prominent garden centre is a detracting feature which erodes this wild character. And this site is part of that incongruous cluster of development that is considered to detract from the overall landscape character. And the in the North Norfolk landscape character assessment, there are sets of guidelines and strategies to conserve and enhance the landscape type. And one of those is cited as conserving the character of villages by retaining the compact character of existing settlement and avoiding impinging on the remote rural character of the surrounding landscape. Just looking in detail more about the proposal itself now, concerns that the proposal essentially extends the built form further south into the site and spreads across the whole site, which will essentially increase the impact of development. The buildings to the south of the site, particularly plots 1 to 4, are taller slightly than the buildings set further back, such as plot 5 and plot 8. And we're slightly concerned about that there will be an increase in lighting and the light spill from the site, despite the mature boundary hedgerow, which the arboricultural impact assessment assesses to be 8 metres high maximum, whereas the plots 1 to 4 are maximum height of are measured off the plans to be about 8.57 metres. And there's a large amount of glazing on each of the end elevations with balconies. And the council's concerned that that will impact on the defined feature of the dark night skies within this landscape type. The existing care home building is set further north in the site, and although it has a lot of windows, they are much smaller and less expansive. Moving on to the layout of the site, the layout results in very little public amenity space, where there's scope for planting to be specified and maintained. And the majority of the site, of the external space, is given over to private gardens where the type of planting cannot be prescribed. The landscape master plan does indicate species which are reflective of the surrounding habitats, but there's very little connectivity due to the existing mature hedge boundaries essentially visually divorce the site from its immediate setting, resulting in very little integration through planting with the surrounding area. And if I could just move on to looking at the impact on the special qualities of the Aomb.
Yes, please.
Okay. There are two key qualities which have been highlighted already, both of which are assessed within the management plan to be in amber condition, meaning there are grounds for concern. One of those is the sense of remoteness, tranquility and wildness. And the council considers that this development would result in increased lighting that would adversely impact the dark night skies, which are a stated feature of this quality.
Just in terms of that, that increased lighting, is that an increase on? Is that an increase on what's there at present, or if it was in its care home use? Is that what you're saying?
Yes, yes, we do think that, you know, because of the location of the dwellings, the large amounts of glazing on each of the end elevations, that, you know, it would result in a net increase. Yes. And the second key quality is the diversity and integrity of landscape, seascape and settlement character. And the council considers that introducing housing into this site would not reinforce the fairly strong settlement pattern within this type of the settlement, mainly along the coast and the village of Kelling. Otherwise, there's very little other clusters of settlement. And as has already been noted in the hearing statement 5.19, the appellant concludes that the nature of change resulting from this development would be neutral, with changes neither adding or detracting. And the council considers that seeing that this area of development, this cluster of existing development, is already highlighted or noted as a detracting feature within the Aomb landscape, then the development essentially offers no improvement, and it's perpetuating the incongruous nature of this group of built form.
So just in terms of what you said there, it offers no improvement. Is it the council's position it offers no improvement, but it's no worse than what's there at present, or is it that it's worse?
I think we have got an issue with the increased light pollution, and then in that sense it would be worse. Yes.
And is it only in that sense that it would be worse?
I think the other sense is that it's actually, as I said, pulling the development south and filling the whole site with built form, whereas at the moment you've got, you know, acknowledged it's a large building, but it is contained and set back into the site. So the council's conclusion is that we don't consider that it conserves or enhances the Aomb as required by Para 176. And in relation to local plan policies, EN1 requires that development should not detract from the special qualities of the Aomb, which we consider this does. And in relation to policy EN2, the development fails to reinforce the distinctive settlement character, which is one of the requirements, and also has an impact on the nocturnal character. And that's it, Mum. Okay.
Thank you. I wonder whether you could perhaps stop sharing that
Yes,
particular.
certainly. Yeah.
Thank you.
How do I stop sharing? Sorry, I'm trying to do that.
Fine.
Lost my screen. Stop share. Oh, here we go. Thanks.
Thank you. That's helpful. Okay. I wonder whether did the appellant want to come back on any of those points raised?
Yes, please.
Thank you.
Yes, ma'am. I'll try and keep it brief. If we could come to dark skies, ma'am. I think Ms. Batchelor did concede that the existing use, the care home, have many windows, but her view is that there'll be additional light pollution with the proposals. Now, Mum, the existing, and I actually agree with Ms. Batchelor, there are many exterior windows there. Technology clearly has moved on. I'm not witness to discuss that, but there will, in my view, be reduced light because of the various technologies. Mum, you'll also note that the roads will not be adopted. There won't be street lighting. Mum, if I could, Mr. Morgan probably is far more qualified than me to discuss the technologies and the proposals with regard to minimising light. So if I could ask Mr. Morgan to.
Okay, thank you, Ben. Yes, so, Ma'am, if I could just refer you to my hearing statement. It's page 24, paragraph 6.31. Where I've discussed the sort of items of dark skies. Now, I think our experience, we've worked on quite a few sites in sensitive locations, such as the South Downs National Park, other national parks, where obviously it's a similar issue really with dark skies. I've appended to my evidence actually some technical guidance from the South Downs National Park, which is quite a useful technical note, dated April 2018. In particular, it's quite a long document. Page 44 of that is quite useful in summarising some of the recommendations that are made in terms of the building construction, in terms of mitigating the light pollution. So that can be done in a variety of ways that I've outlined in my statement under section 6.32. So some of those things will be controlling the direction of the light fittings so that we focus light at low level. In terms of the glazing, the special glazing we can get these days, either tinted glazing or low transmittance glazing.
Sorry, can I just stop there? I've got a bit of feedback. I don't know whether anyone else is picking that up, but I don't know whether it's from your your room maybe. I'm just
Is that
I'm getting a lot of keyboard sound, Mark.
keyboard noise. It's just got to a level where I just can't quite hear what's being said. But if we just carry on, you'd mentioned special glazing. I think I've heard.
Okay, I'll try again. Yes. Yeah, so you can get glazing that's either tinted or low transmission. We can go another step on from that, which is what's called smart glazing, which is an electrochromic glass, which you can almost switch on and off with a switch. You may have seen things like that on Grand Designs and other programs. So that effectively sort of switches the glass into an opaque state. We could detail in integrated automatic blinds that are integral to the glazing system, and they can be on a timer. We can use automated dimmer switches, which again can be on a timer. And in particular, the specification of the lighting and the colour tone is very important as well. And the South Downs guidance recommends colour tones that are less than 3000 Kelvin. And we can also restrict the lamps we put in to, the recommendation is 500 lumens. So there's a variety of things that can be done at the detailed design stage that can help mitigate light pollution. I think the other thing I'd point out with the design of those houses, where they obviously the object of them is to achieve solar gain, and that is something encouraged by policy EN6. It's encouraged in the Norfolk Design Guide. And in particular, if I could take you to paragraph 5.10, 510, my proof, where there's an extract from the Norfolk Design Guide, which has contemporary interpretations of local building forms will be encouraged and welcomed, with particular emphasis on using more natural light in the design of buildings. And again, in policy EN6, there is a big emphasis on the solar orientation and making the most of the natural light as part of a sustainable construction approach. The way we've designed the houses, we've placed the bedrooms on the first floor. So where the glazing does extend up into the apex of the roof, where you have the largest area of glazing, that is actually a bedroom rather than a living space. Obviously, as a bedroom, its use is more intermittent. So it doesn't have the same extent of use as a living space would have. You maybe have the lights on in the evening for sort of half an hour, 45 minutes before you get to bed in the evening. And because it's a bedroom, you're naturally going to want privacy as well. So in a way, these mechanisms such as the blinds, the dimming lights, is something that I think would be self-policing to a degree, because the occupiers would be looking for a sense of privacy. Yeah, and just as in comparison with the care home, which is obviously the baseline situation, none of these features are on the care home. The extensive areas of glazing. The care home is higher and has quite a lot of glazing on its attic floor. A care home would also be in more constant use, particularly throughout the night. It would be a 24-hour-a-day, 7-day-a-week operation. Staff coming and going, cars coming and going in shift patterns, introducing light. So I would say the existing situation is far worse than, and we could actually enhance the design and reduce the amount of light pollution with our proposal.
Just in terms of those mitigation measures, do they form part of the plans and the conditions, or would that require an additional condition add-in? I'm just.
There is a condition proposed.
Yeah, I believe there is a condition proposed, condition 20, which is a condition on window shutters and glass.
Yeah.
As well as large-scale drawings, sections of the windows, technical details, measures to limit artificial light transmission to be used in the construction. Oh, and also condition 19, which covers external lighting. So I think between those two conditions, it's possible to control the level of lighting in the scheme.
Okay, does that cover the technical bits on dark skies? I think you might want to, I can see a hand raised. You might want to go back to the other issues that Ms. Batchelor mentioned about sort of the encroachment of build towards the southern boundary.
That's correct, Mark. I just want to, just some minor points. There was a discussion about public-private open space. Now, I'm travelling through North Norfolk, looking at various settlements, the settlement grain, if you like. There is very little open space characteristics within those villages. So I believe Mr. Morgan has taken that on board and used that as a design theme. In terms of species connectivity,
Thank you.
Species connectivity, clearly the western boundary lies adjacent to woodland, and clearly there'll be links there. In terms of visually divorced from the wider setting to the east and south, well, there wouldn't be any visual connectivity because the components of the heathland are not represented in that locality. As such, the appeal site is an island that is devoid of all those special quality characteristics. And I've covered the special qualities regarding the amber, those 2 points, I think previously. With regard to the neutral effect, well, it's neither tremendously enhancing or tremendously conserving. It is conserving and enhancing, but there is a degree of. Now, I completely disagree with there'll be no improvement in relation to the existing care home. Clearly, it is lower. The components are lower. It's not derelict, ma'am. And I believe, as your site visit would have confirmed, there are very few public locations where you can perceive the existing care home. Clearly, it is taller than the proposed. And as such, from those visual locations, there would be improvements. There would be less built form from those viewpoints. But also noting, ma'am, that you would have built form within that view as well. So not introducing any alien components within that view. Just finally, extending development further south. Again, Ma'am, it's the question of where you'd see such a development, and I would suggest, because the ridge lines are lower, heavily visually contained southern boundary, there'll be a negligible to none experience. Well, thank you.
Thank you. Just in light of that, I will just ask the council if they wish to comment on that. I'm conscious we might be going backwards and forwards, and I might be inciting people to repeat things. But if there is anything that anyone wishes to raise, or any third party who's listening in, please feel free to raise anything there. Ms. Batchelor.
Thanks. I just think we do have issues about the large expanses of glazing, and that remains really, despite the explanations by the appellant. And also the fact that plots 1 to 4, the end elevations with the glazing face onto woodland, which is typical the bat foraging areas. There are bat mitigation measures, which we'll discuss later, that are not in that location. But in terms of light spill onto areas where there may be protected species, that was just a minor issue. And just to repeat about the fact that there is no integration of the new development into the surroundings. It's really just replacing one building with another. And in terms of benefits to the locality, it's very minimal given the very strong boundary hedge. And I think my colleague Philip Rowson wants to say something. Thank you.
Mr. Rowson?
Very briefly, Ma'am. The issue for the two parties, I think, is neatly described in the exchanges today. From our point of view, the concept of the site as an island is something that is not viewed by us favourably. We don't agree with that. The site should integrate more broadly with that wider landscape with the Aomb, and I think those issues, when you examine the differences between the two cases, are at the heart of this disagreement. Mark. Thank you.
Thank you. Okay.
Sorry, Madam, can I just make 2 very brief points? One, I think it's clear from what was just said, but there is no objection on ecological ground. I think we started getting into an ecological objection, but I just want to clarify there is no ecological case from the council, and if that's now to be made, I would of course speak to call the witness on that. And the second point in relation to the integration one, there is of course a condition about the landscaping scheme, and if the council wish to see this site landscaped in some different manner than the one put forward in the landscape master plan, that would be in their hands.
So if I could just, I think Mr. Rowson, you've got your so I think just there were those 2 points in terms of the ecology.
Absolutely, Mel. The council aren't trying to reinvent and introduce a reason for refusal here. It was a point in passing from my colleague that related to the wider interests of the matter of landscape and foraging. We're content with the position under the unilateral undertaking. Regards the matter of integration, I don't think I can put it any more plainly than I have done previously. No amount of landscaping or changes can get us over the clear separation of positions. And unfortunately, Mum, I have to rely on you to pick the bones out of this as our decision maker, and I respect your position. Thank you.
Thank you. With those comments in mind, do parties wish to proceed with the design points, and then I think after we've concluded that matter, if we then break for lunch then, but these two main issues sort of flow into each other, so it seems a sensible.
We're quite content with that.
Okay, so if we deal with design issue again, if you wish to just briefly highlight those issues, I have had regard to what's been written. But if anyone wants to draw anything to my attention, please do.
Okay, thank you, Mum. I'll briefly just pick up on probably about half a dozen points that I think are come out of the council's statement, and that covered in my hearing statement as well. But I think first of all, just to say at the outset, I mean, this is a high quality, innovative design. It's highly sustainable in its construction. And in those terms, it's ticking all the boxes in terms of policies, EN4, EN6, which talks about sustainable construction, and also the North Norfolk Design Guide, which is very proud in terms of encouraging innovative and sustainable design. In particular, if I could refer you to, in the adopted North Norfolk Design Guide, paragraph 2.2.
Sorry, was that the adopted one or the unadopted?
The adopted one to start with, yes, 2.216. And I'll just read a sort of brief extract of that. It says, new buildings do not have to copy their older neighbours in detail. Some of the most interesting streets include a variety of building styles, materials and forms of construction of many different periods that work together to form a harmonious group. All too often, however, people shy away from creating contemporary buildings for fear of them not being accepted locally. This results in pastiche buildings which simply revisit traditional architectural forms and motifs. While there will always be a place for such unobtrusive buildings within North Norfolk, there is a risk that the overuse will deprive the district of real innovation and visual interest. And the emerging North Norfolk Design Guide, I think, is similar, if not stronger, on its encouragement of contemporary design. And in my evidence, under paragraph 5.10, there's an extract which says contemporary interpretations of local building forms will be encouraged and welcomed, with particular emphasis on using more natural light in the design of buildings, or articulation to the elevations, and use of locally distinctive materials. And in the there's a selection of images in my statement under 5.11, which are extracted from the emerging North Norfolk Design Guide, which show some exemplary images of schemes using contemporary forms. In particular, you can note the sort of innovative use of materials, but also locally distinctive materials such as cobbles, blackboarding, the long gabled forms, the long ridge forms and narrow gables. I think just going over the page 5.12, then there's North Norfolk have a design award called the Graham Allen Awards, and there's two examples on page 12 of my statement that show contemporary buildings. Both have metal roofs, as does our proposal, so standing seam roofs. I think the top example, Edgefield, has a lead roof. The one below has a copper standing seam roof and copper cladding. They use timber boarding and cobbles. So I think that as a sort of overarching statement, I think the innovative design and sustainable construction is really achieving the benchmark and the aspirations of the planning policies. If I just touch on the sustainability side, sustainability construction, in terms of what the scheme's delivering, in terms of the energy source, we're not relying on gas boilers. We're using air source heat pumps, underfloor heating, mechanical heat and ventilation recovery. The dwellings are all oriented in their design for solar gain. And in total, we're achieving a 60 to 65% carbon reduction over 2013 building regulations, which is setting the bar or the standard higher than the regulations that are being modified this year. So it's going above and beyond that. We're also looking at a variety of other sustainable construction features, recycling storage, composting, rainwater harvesting for garden use, obviously things like water meters and low flow sanitary ware and taps, low energy light fittings, electric vehicle charging to all plots, and promoting sustainable travel with cycle storage. So there's a range of measures that actually go beyond policy EN6 for sustainable construction. The other issues I wish to pick up on were really more to do with the layout and design, and I think just pick up some of the comments from Mr. Young that he raised in his the consultation comments. So one of the first, probably the first point is I suppose the layout disposition of built form across the site, which we've sort of touched on with the landscape comments. Now, in our view, or the approach we've taken is to place the higher buildings towards the woodland edge and then have a transition from the south to the north. Now, in the work we've done in 3D modeling the site and testing certain viewpoints, if I could draw to your attention Appendix H of the, I think it's the planning statement. It has a photo montage view taken from the Holt Garden Centre next door to the site. Now the view, there's a sort of before and after view. So the view at the top of that page shows the situation as existing. And you can see with the existing care home, which is 2.5 stories in height, that actually it stands quite proud above the roof of the garden centre when viewed from the car park, which is probably one of the main public viewpoints of the site, really. And I think by pushing, contrary with our proposal, by pushing the development to the south towards the woodland edge, having the higher elements there, and actually fragmenting the main building form. So instead of having a big, massive care home form in the centre of the site, we've fragmented it into smaller forms of lower scales. In the view below, you'll see that actually all you're getting is little sort of glimpses of the elements of the roofs, really, which are far lower. So, in my view, there is a visual improvement there, an enhancement there. There was less impact in terms of the bulk and the scale. And just to clarify a few facts, I suppose, on the scale. I mean, the existing care home is 2.5 stories high. And that's quite clearly shown. I think it's page 7 of the DAS, which has got that useful aerial photo. The proposals are lower. So we have a transition in scale across the site. So plots 1 to 4 are 2 stories, well, their ridge height is 8.7 metres. The care home's ridge height is 9.4. And then when we move northwards to plots 5 and 8, our buildings decrease in scale to 1.5 stories, so 7.2 metres. And then as we get to the very northern edge of the site, we have single story buildings, so they're 3.5 metres tall. But the whole strategy in the design has been to minimise that impact from that key viewpoint by the garden centre and break up the massing. If I could just move on to another point raised by Mr. Young, was in terms of development, he mentions about what he describes as regimented and suburban form parts of the layout, and I think particularly he's referring to plots 1 to 4 on the southern edge. I think it's important to look at the development as a whole, and I think the approach we've taken is what I describe as a clustered form of dwellings. And this ties in with some of the North Norfolk design guide in terms of, if I could draw your attention to paragraph 5.09 of my hearing statement, which talks about the emerging North Norfolk design guide, which actually identifies different typologies, to different ways of designing schemes for depending on their size and location. Now this scheme falls into a typology that we've assessed as, that is assessed in the design guide as scattered dwellings, which the key characteristics of that include rural forms, open massing and grouping, a scale of 1 to 2 stories, and on-block parking. And I would say that's precisely what the design achieves. I think particularly in that southern edge of dwellings, plots 1 to 4, what we've tried to do is alter the siting of each dwelling. So they're actually arranged on a slight curve. So when you look along the street, it breaks up the rhythm that you see, and that's illustrated in page 18. There's quite a useful view in my statement, paragraph 6.15, which shows, because of the curved form that those dwellings are laid out on, that when you're standing in the street and you look along that street, what you see is you're not seeing an identical view of each dwelling. Because of the angle and the way they turn, you see a different amount of the front elevation and the side elevation, which breaks up any formality and rhythm. I would also say, in terms of the massing and actually the design of the buildings, plots 2 and 4 are a different design from plot. Sorry, I got that wrong. Plot 1 and 4 are a different design from plot 2 and 3. So there's a variety in the style. You'll see on plot 1 there's more of a setback, where you've got the sort of the balcony at the front. So I think the other thing is the street is informal and winding, which is not a suburban character. There's a variation in the setback of the front gardens. Plot 4 actually has obviously a much bigger front garden than, say, plot 2, for example. So there's informality in the front gardens and setback. There's informality in the streets. And I think when you're standing in the street and you're trying to assess the character, you're not just looking at one side of the street, you look at both sides of the street as a whole. And actually, for something to be suburban, it needs to be suburban on both sides. And obviously plot 8, which is in the centre of the site, is a very different configuration from 1 to 4. So I think when you're standing in the street, you're reading both sides of the street at once to get an appreciation of the character. So I think the combination of everything I've just mentioned there, I would describe the development as clustered informal forms. And I don't agree with the characterisation of suburban. Just to pick up on, I think probably 2 more points. In terms of, I'm going to sort of paragraph 6.23 of my hearing statement, which is really talks about, it starts off with a quote from Mr. Young that says, "These two-storey buildings are also certainly not without their design merit and feature interest and innovation in equal measure. However, they are not structures one would associate immediately with our particular district." So I think there's recognition of the positive design qualities, but I think in terms of what makes them distinctive to the district, the approach we've taken is to look at, firstly, the materials palettes we've used. We've potentially used materials that are local, so the cobble walling, the black timber weatherboarding, which is referenced in the Norfolk Design Guide. We've also used the standing seam roofing, although historically that's not a traditional material. It is a material that's set out in the Norfolk Design Guide. In the emerging guide, I think there's 9 case studies of proposed schemes which are held up as exemplars. And out of those 9, 5 of them use a standing seam metal roof in full or part. So it's obviously an accepted contemporary approach to the way buildings can be roofed. I think the other thing we've done to make a nod to the, I suppose, the rural character of the scheme is to look at agricultural forms. So in the way the buildings are designed, they're intentionally designed with a long ridge and a narrow gable, which picks up on this sort of traditional barn forms and agricultural forms that you would see in a rural setting. But it's done in a contemporary way, in an innovative way, in terms of the way it's designed. So we're tying into the history and what's locally distinctive about the area, but reinterpreting that in an innovative way. And I think there's a very similar approach, paragraph 6.26 of my statement. Shows a building, it's called the Black Barn, which won a 2019 RIBA East Regional Design Award. And you can see similar approach in terms of the black cladding, the very long ridge, the glazed gable end, the cobbled base to the building. And obviously that's a building that has received a great deal of recognition. It also has a standing seam roof. And I think finally, my last point, it was really just wrapping up some of the, really what I'd describe as points of detail, really, raised by Mr. Young. So I think there were some details or questions on how the standing seam roof on the buildings would be perceived. Would it look sort of repetitive or not? And also some comments on the sedum roof detailing. That was for plots 6 and 7. So I think in my statement I've outlined a few ways where I think the standing seam roof could, subject to a matter of condition, be detailed in a way, either in terms of pre-patination to change the colour hue, or in terms of the spacing and the way it's detailed on the roof, that would give, you could do it in a way that each building has a slight difference to it, really. That would, I think, address that concern of things looking repetitive. And finally, on the sedum roof, I think the comment was the eaves were perhaps a bit too clipped, really, or stunted, I think was the word used by Mr. Young. And I think, our approach had been to have sort of fairly clipped eaves to all the development as a contemporary design approach, but not notwithstanding that. I think the matter of the eave detail could be addressed by a suitably worded planning condition if it was felt that was important. And the buildings could equally be designed with a larger overhanging eaves. I don't believe there was any objection to the cedar roof. So I think that's from my side, that picks up probably the main points really that's sort of summarised in my statement. That's helpful.
Thank you, very helpful, thank you. Mr. Young, did you want to respond and give the council's view?
Yes, please. I think the first thing to say, we in North Norfolk are extremely proud of our built environment. We were one of the first local authorities to have a design guide in the country, published in 1974. And that's based very much on the strong vernacular traditions in the district. Now, when we came to write the adopted version of the design guide and the associated policy EN4, there was very much a concern around pastiche buildings and pastiche design. And there was often a thought with agents, if they offered a bit of flint and something that looked like a cottage, they might get permission. And we were concerned about that, which is why we drafted EN4 and the 2008 adopted version of the design guide in quite a progressive way. So there are, as Mr. Morgan has identified, numerous references to encouraging innovative and energy efficient design. In fact, we particularly encourage that. But what he's not so much focused on are the checks and balances to that. What EN4 and the design guide don't offer is a green light that in a way would throw the baby out with the bathwater. Because we have got such a distinctive built environment. Yes, we are accepting of innovation and eco-focused design, but equally the form and character of the area, local distinctiveness and the local context are very important. So EN4 particularly talks about developments being suitably designed for the context within which they're set. And it also cross-references across to the design guide. Now, in the design guide, I needn't read out the section on pastiche buildings because Mr. Morgan has kindly saved me that job. But what the next para does talk about, it cautions against the use of crisp contemporary architecture, which can be created, which ignores local context. And that can be equally as damaging in terms of perpetuating or not perpetuating local distinctiveness. So as part of the vision within the design guide, it comes up with a number of criteria for successful schemes, and one of which is about reinforcing development patterns and the form and character of the surrounding area. So when we then go into the sort of the nuts and bolts of the design guide, again, Mr. Morgan's referenced the section on residential development, where it talks about siting, grouping and enclosure, which is para 3.3.7. There it talks about in a rural area like North Norfolk, informal groups of houses tend to be more compatible than any geometrical configurations. So I think for me, that's a key point. And then picking up the point on solar gain, in the very next paragraph on orientation, which is para 3.3.8, quite rightly, it talks about buildings, they should be orientated to make maximum use of passive solar gain. But again, the checks and balance there is that the form and character of the area may dictate a particular arrangement of buildings which are at odds with this objective. In such cases, it will be for the designer of the scheme to creatively combine both constraints. So it's about balance. It's not about accepting innovative and eco-based schemes without regard to the local area. If we translate that across to the national context in the MPPF, again, Mr. Morgan has quoted the two paragraphs in his statement that I also would use, which is 130 and 134. Both of those talk about developments being sympathetic to local character and history. And they also, as well as encouraging outstanding and innovative designs, 134 particularly says its closing gambit is so long as they fit in with the overall form and layout of their surroundings. So again, context is extremely important. So turning to the scheme in front of us, what I see is a scheme that quite rightly has given due weight to maximising solar gain and not slavishly copying vernacular built forms. So yes, it starts to tick boxes in terms of the design guide. And I also see individual buildings with aspirations to deliver more than just generic house types. You know, we're not suggesting this is a persimmon housing scheme. And it also obviously embraces sustainable construction principles. But what I don't see is a scheme which gives equivalent weight to compatibility and how it responds to the surrounding form and character of the area. And I don't see the kind of informality and creativity which is required by our design guide, or the sympathy and policy compliance required by the MPPF. So just exploring this a bit more, if we look at the surrounding area, it's a predominantly rural area, and you will find that there are two basic building types there. There are individual standalone buildings, houses generally in the countryside, and there are also clusters, individual clusters, whether they're farm groups at places like Lowes Farm, which lies just to the west of the appeal site, or actually the stable yard and estate office at Kelling Hall. So you've got a combination of those sort of agricultural meets residential clusters, and then within Kelling village itself, you've got a range again of mainly residential, but also with some farm buildings. And I'm thinking particularly of Beck Farmhouse and the cluster of buildings, which again, Mr. Morgan helpfully provides an illustration in his proof. But when I think about what informal is, and particularly the paragraph in our design guide encouraging informal groupings, I think about buildings and spaces which appear to have adapted over time. I think about additive and incremental layouts where there's codependency between the buildings. And I think of organic and ad hoc relationships between elements, natural and unnatural, and a general lack of delineation and definition. But what I don't think about is architectural prescription or following particular rules. And I don't think about buildings standing on ceremony or following particular rhythms or patterns of development. And also, I don't think of necessarily design symmetry or predictable relationships between buildings. And finally, I don't think of independent standalone dwellings with similar on-plot provision or serviced with hammerheads and footpaths. That's not what I immediately associate with informal. And that is the council's position. Essentially, that's what we have here. So for plots 1 to 4, we've got a row of very similar buildings. And in fact, in page 39 of the original design and access statement, where it refers to plots 2 and 3, it actually confirms that. It says these houses are very similar to plots 1 and 4, with only one terrace facing south. And it also refers to the porch and garden widths, the garden widths and the variations between them. But to my eye, adding 2 porches onto 2 of the buildings doesn't create an additive and incremental layout. These are very small additions to the 4 properties. They are essentially, as they're probably best illustrated actually in the street elevation A to A that was accompanying the application. What you've essentially got are 4 very similar elevations presented to the road. Yes, they fan out, but that to me is not a rural configuration either. it has a formality which I would associate almost with lodge-style developments in leisure parks. This is not what you would find in a rural cluster of buildings, particularly plots 1 to 4. There's inherent symmetry amongst them. So plots 1 and 4, the two outer plots, are exactly the same, and the two in the middle are exactly the same. And the variations in garden width are so subtle as to be negligible in real terms. What you've essentially got is a row of dominoes there, which to me speaks of regimentation. It doesn't speak of informality. So just moving across to the rest of the scheme, again, what we've got here are 8 essentially individual standalone buildings. There's very little dialogue between them. There's no collisions between the individual buildings. They are in essence detached properties standing in their own grounds with similar on-plot provision. So I don't subscribe to the view that this is an informal scheme. This, to me, as I've put in our proof, is rooted in the suburban, essentially, albeit, yes, it has a contemporary aesthetic in terms of the way it's been designed, but ultimately this is not a development which speaks to the form and character of the surrounding area. And just finally, on the sort of more detailed elevational matters, Mr. Morgan's quite right. I did deliver quite a balanced critique of the scheme when it was originally submitted, and I did acknowledge that the buildings have merit from a visual point of view. Again, they're not standard generic house types. They offer more than that. But I don't think it's not something I'd particularly want to overplay. And the reason I say that, within the original design and access statement, where it refers to the pre-application inquiry, it talks about modular house forms, and particularly it makes reference to CABU modular house types. Now, there isn't anything explicit in the application submission which leads me to the conclusion that these are definitely CABU modular house types, but equally a quick search of Google Images throws up a number of equivalent images of buildings which are extremely similar, almost to, well, on plots 5 to 8, for instance, even the angled corner. So that, in principle, it's not something I'm resistant to, and particularly not in the current climate where we obviously need to move away our reliance on wet trades. But it does raise question marks with me that if they're coming on the back of a lorry, just how locally distinctive are they likely to be? Now, what that obviously means is increased reliance needs to be placed on materials and the layout. Now, based on the comments I've already advanced, I think the scheme is deficient in terms of its layout and compatibility, which leaves us with the materials. So at ground floor, we have flint panels, which, yes, flint is a distinctive material that you'll find throughout Kelling and this part of the district. You will also find examples of boarding within our district. But I think the original design and access statement and Mr. Morgan's appeal submission, I don't think they seem to have slightly misread the local vernacular, because boarding in an agricultural sense is something that is used as an accent material. This is about infilling a cart shed. And to be perfectly honest, it's more associated with the barn conversions of the late 20th century and early 21st century. Traditionally, all our agricultural buildings in North Norfolk are masonry built, whether it be brick and flint. And the precedent examples that he has quoted, you will find that none of those are in our area. Now, the comment has already been made about the new design guide and the fact that very little weight, we are giving very little weight to it. a lot of water has gone under the bridge since that draft was first produced in terms of government guidance. But having gone back to it and looked at it, the essential messages are much the same. It's all about the importance of context and form and character. The examples are cited in a generic way to show what is possible. But what it doesn't say or advise people is if you come up with a scheme with 4 consecutive gables, all of a similar appearance, will it be acceptable in a rural location? Nor does it say if you design a very long black barn in a contemporary idiom, will it sit comfortably within a North Norfolk context? So I think that is an important point to get across. And one final point on the issue of the zinc. Again, Mr. Morgan is perfectly correct. We do have precedents for the use of zinc and various other modern materials in the district. That's something I'm particularly encouraging, to move away from just a standard palette of materials. But what you will find as existing, they are all standalone buildings. What we don't have as yet, other than one example in Fakenham town centre, where we have a number of buildings together that are all in zinc. So again, if I come back to the notion of an incremental or additive form of development, which will sit comfortably in a rural location, immediately proposing a distinctive material like standing seam, whether it be zinc or turn-coated, immediately you're talking about uniformity. And yes, you can pre-patinate, you can subtly change the shades, you can alter the rhythm of the standing seam, but ultimately that plays to uniformity rather than additive qualities. So I think that's all I need to say. The slight crossover to landscape is the sense, yes, this is a self-contained site, but ultimately there are glimpsed views, not only from the car park of the garden centre, also around the back in the seating area, behind the garden centre, behind where they sell the outbuildings. I've paused and reflected there on a picnic table many a time. And the difference in height between the existing care home and the proposed buildings is 0.7, the maximum on plots 1 to 4. So that's not a huge decrease. So what you will find in practice is the apexes of those 4 buildings will poke their heads up above, they'll announce themselves above the beech hedge, and you will get a general perception of the built form extending into the countryside. But even beyond that, ultimately, once built, that scheme will be experienced by anyone visiting the site, whether it be the occupants, their friends, visitors, anyone delivering a service to the site. So in my view, it's important that the scheme sits comfortably within its setting, whether it happens to have a high level of self-containment or not. So with that, I will give way.
Thank you, Mr. Young. Did you wish to come back on Mr. Young's points there?
I'll try and pick up on a few things. I think a lot of the points I'd sort of covered in my initial statement anyway, but I entirely agree that development needs to be sympathetic to its setting, really. And I think that's something we've strived to do with the design, really. And I would just sort of reiterate the agricultural forms we've used in terms of design and the reference to the palette of materials as a way of doing that, as well as being innovative at the same time. I think with all design approaches, there's obviously, for the designer, there's always a balance of things to weigh up, really. And I think sometimes those things are conflicting as well. And so, for example, the orientation, we really played on that in terms of the design and tried to do the best we can in terms of that, in terms of meeting policy EN and 6. And I think that delivers a certain aesthetic, really. And I think that's not dissimilar to many of the exemplar precedents in the North Norfolk Design Guide. all the award-winning schemes in the district, really. We deliberately tried not to be pastiche and tried to put forward an innovative scheme. On the point to do with, I think, the modular construction, the intention is that the scheme uses modern methods of construction. We're not wedded to a particular manufacturer at this stage, but we've been looking at sort of SIPs, what's called SIPs panels, structurally insulated panel systems, which means the development would be sort of fast tracked, but it would also be highly airtight, and it makes it more sustainable and energy efficient as well. And there's all sort of in accordance with sort of best practice. And I think finally, I'd just say in terms of the setting, I mean, the setting is, it's not a site in isolation really. I mean, it's a site next to quite a large garden centre development as well. And I think that forms part of its setting. Quite large scale agricultural form buildings, a lot of metal roofs, a lot of glazing, quite intensively developed, and it's seen in the backdrop of that as well, really. So that all sort of weighs in as part of the setting and the design approach, really. I think it's not a site in the middle of nowhere in that respect.
Thank you. Does anyone else wish to say anything on design or landscape? Okay. Well, on that note then, if that's the case, it's now coming up to 1:30. I'm conscious it's past lunchtime or at lunchtime.
Sorry, ma'am, I didn't manage to unmute him because I've just reminded we didn't actually cover visual. We did landscape and then went on to design.
Let's cover visual before we break for lunch.
I can be really quick because there's very few issues here. Perhaps if I just very quickly summarise visuals, and that's on page 39. So you note that we have reviewed 11 viewpoints. Just as a summary, 6 are minor beneficial. 1 is negligible, none, neutral. And 3 lie within the wider A and B, and there is no effect on those marks. And just pick up on that recent comment about the cafe. I mean, note that is viewpoint 2. And the existing photograph, ma'am, does not show the 2.5-storey due to intervening vegetation. Thank you, ma'am.
Thank you. Did anyone from the council want to come back on that? I think just one other point, whilst I have all the relevant experts on landscape and design, just in terms of site visit, because this might not be a point that we discussed today, and I'm conscious that people might not want to make themselves available for a full day tomorrow, but it might be worthwhile discussing just as part of this issue if there are any other points of view that you wish me to view the site from, or alternatively other areas where you think I need to have a look at the distinctive character anywhere else.
If I could maybe jump in there, Mum.
Yes.
Yeah, the two examples that I cited, to illustrate the clustered form of development, it may be worth your while to view. One is Lowe's Farm, which is on Bridge Street in Kelling, which is literally about half a mile to the west of the appeal site. And then the sort of ancillary stable yard and estate buildings to the hall. And also, I think you'll get a very good flavour for the setting just driving through the middle of Kelling village, particularly in and around the area of Beck Farm. In terms of views, I think one of the key views is from the garden centre car park, and then all of the areas around the back where people can take their coffee out there, or the play areas or whatever, where people pause and take in the air. Obviously, depending on the time of year and the beach hedge, there'll be glimpse views from there. So I think it's worth you taking in that. I wouldn't necessarily suggest you get on the North Norfolk Railway, although the slow speed that goes past, the roof, particularly of plot 1, would probably poke its head up, but I don't think that's a point we would particularly labour.
I presume that all those particular points that you've just suggested I go to, I can see those all from the public domain, I presume.
Probably not for the actual hall and the stable yard. But that's in the applicant's ownership.
Thank you. Thank you.
Mark, I would suggest also you'll note the no effect to the wider setting. I mean, I don't think, unless Ms. Batchfield wishes you to go there, but if there's no effect, there's no effect, Mark. So it's highly localised car park road, Mark.
Okay. Has that covered everything for everybody? Okay. I'll adjourn for lunch. Would 2:15 suit everybody? 45 minutes? Okay, I'll adjourn until quarter past 2. Just in terms of the time that I sit until today, is anybody restricted at the other end of the day? Does anybody need to get away? No. Okay.
No restrictions for us.
Right. Okay, that's fine. Just in terms of I can then move things around if necessary. But if that's okay with everyone, I'll adjourn until 2:15, and I'll see you then. Thank you. Good afternoon. Can everybody hear me again?
Yes,
Good.
good afternoon.
Fabulous. I think we have, we look like we've got most people back, unless anyone can see anyone missing. In which case I will continue with the hearing. It's reopened. So if I just turn back to my agenda, I think the next item on the agenda, I think we've already touched upon in part. Oh no, sorry, we haven't touched upon in part. This is the effect of the proposed development on local facilities and services. This is in respect of policy CT3, I think. Again, I've read the submissions on this particular matter, but I'd like to hear from the appellant sort of a brief outline as to their case on this matter, and also I think you were going to refer me to those two, or certainly one recent development where that policy was, you suggest, wasn't referred to. So perhaps if I go to the appellant and in the first instance.
Thank you, Mark. Can you hear me okay?
I can, yes, thank you.
Thank you, good. Yes, CT3. I think in a nutshell, CT3 and how our site sits with it is fairly straightforward in our submission. The first submission is that it doesn't, CT3 doesn't seek to control care homes. And I'll point to a number of matters for you on that. Firstly, madam, is if you've got CT3 in front of you by any chance.
If you just give me a moment.
Of course.
We'll just find a relevant policy. Right, I have it in front of me.
Thank you. And you'll see at the bottom there is a list of important local facilities and services, which obviously is the key part of CT3, and it sets out a list of uses. Now that doesn't include care homes. And I'm sure the council are going to say it's not an exhaustive list because it's got includes. But nonetheless, I take the reading of those uses as being ones which are available for the wider populace to make use of. So if you look at them all, they are all facilities where any type of health, a care arrangement or age or anything like that would be a controlling factor. They are all available for the wider populace to use. So that our view is that it doesn't, care homes are not included in CT3. And to back that up, madam, there are a couple of other places to look at. Firstly, the council's planning policy response from Ian Withington to our application, which is dated the 29th of the 9th, 20, a long time ago. It's an exhaustive consideration of the policy. He considers all of the policies, but he doesn't mention CT3 once. It's just not mentioned at all. So again, I would have expected that to actually appear within the planning policies remits. Instead, we received correspondence from the council's economic development officer in respect of CT3. So there is an email, madam, from Stuart Quick, dated the 24th of February, which I think is in our appendices. And that is the first time we ever received anything formal from the council in respect of CT3. And for you know, Madam, I think if I can just make reference, we didn't actually see this email until the 24th of June. So obviously, if you look at the committee report, there is a note which says advice to follow. So we didn't actually see this note at the time our application was considered at committee. It was reported as being an issue, but this email didn't actually materialize for us until sometime later, despite asking for it on a regular basis. We then had ongoing discussions with Mr. Rowson about CT3 in particular, and we received on the 23rd of December 2021 an email from Mr. Rowson. I don't know whether you have that, Madam.
No.
If you don't, I can either provide it to you or just read out the.
Can I just let me just have a quick. If that was attached, that would that have been with your appeal statement?
I'll go in later when we look at the document. Okay.
I can't think that I have seen that in all fairness.
Okay. In which case I can move on, because the point I wanted to make there is that the council was still maintaining their position on CT3 being relevant, despite the Bacton application. So that was just linking me to that one. So you don't need to see that particular email. But in terms of one of the additional sites which we placed in front of you, you have a committee report, an email, and a decision notice. Now, the application involved a change of use from a residential care home to 2 dwellings. Again, within the committee report, there is absolutely no reference to CT3. And the email from the case officer to Councillor Clive Stockton, in the second paragraph, makes it clear that a care home would not strictly fall under the definition in policy CT3 in respect of local facilities and services. So that's when we found that, we did again share that with Mr. Rowson. Mr. Rowson came back, and I say he may cover that point again in his response to today. But what we're looking at clearly in my mind, Madam, is a situation where CT3 does not apply to the loss of care homes, and there is evidence to back that up that the council's policy officers and development control officers agree with that position as well. So that's the first point. I don't know whether you want me to stop there, or you want me to cover everything on CT3 and then.
I think it's probably best to stop there and invite the council's comments on that. I think Mr. Wilson will want to comment on that, and then I'll come back to you.
Sure.
Thank you, Mum. That's a useful opportunity to pause and comment. I'm going to defer first of all to our policy manager, Mark Ashwell, and then I'll speak. Thank you.
Okay, so I think there's a couple of points I'd like to make right at the outset, really. The first is that my view is that CT3 is applicable. I'll explain why. It talks in the first part about the loss of important local facilities. And as the appellant has pointed out, that is informed by a footnote at the foot of the policy, which lists some examples of what those local facilities are. And he's made the point for me that the list is including, so it's not an exhaustive list, it's a list of things which would fall into the category of a local facility. So by definition, any other local facility which is important to the area can be, and in my mind should be, covered by the policy. even if you were to take a view, and I think it is a view for you to take, that the policy doesn't expressly relate to the former use of the site, you can go straight to paragraph 93 of the MPPF, which encourages local authorities to do much the same thing that this policy aims to do, and states that local authorities should guard against the loss of valued facilities and services, particularly where this would reduce a community's ability to meet its own needs. And I would say one of the needs that a community will have will be to meet the need for a broad range of housing, including those for the elderly, the infirm and the disabled, which are a large constituent group in North Norfolk. So even if the local plan were silent on this entirely, and I don't think it is silent on it, I think it rightly includes a policy which extends to this type of proposal, the council would be content for you to rely on the MPPF and the paragraph which talks about the retention of these types of services. I can't speak to the history of the case officers dealing with the application or other applications in the district, because I had no personal dealings with those. So that might be an issue that Philip might want to respond to. I think the notion that the absence to reference of a particular policy in a committee report or an email suggests that the council is therefore barred from applying that policy to any future planning applications. Again, doesn't stand up to logical argument. The policy is an adopted policy. If in a previous case, a case officer has neglected to refer to it or taken an inconsistent approach to the application of it, that doesn't undermine the effectiveness of the policy as written and how it should be applied to this proposal.
Mr. Osen, are you able to fill us in on the other development at Bacton, or do you not?
Absolutely, yeah. Please let me do that. I think it's first and foremost important to be technically accurate as to how the decision was reached at Bacton, as against the decision that's subject to the appeal today. The decision at Bacton was a delegated decision, which was subject to a ward member referral process. The decision that we're considering today was reported at length to a development committee and subject to full democratic consideration. So at Bacton, I turn, Mum, to the officer's delegated report. And like delegated reports should be, Mum, it's a concise report. It reflects the fact that there were not significant objections raised. We know that. In the second bullet of that report, the case officer talks about the potential change of use of rural buildings and dwellings as being acceptable under policy SS2 and HO9. The appellants are correct. There is no mention of CT3 at this stage. However, as I raised earlier in this discussion today, the officer goes on to talk about the buildings are in good condition and would be entirely sustainable for residential use. The report goes on to say it recognises that the proposal would result in the loss of a care home. However, there are a number of other care homes available within Bacton, and as such, it is not considered that this loss can be adequately resisted. The officer talks that on balance, the principle of development is accepted. So I would disagree respectfully with the appellants and say that there is a reference to the loss of the care home as a local facility, if not broadly under the CT3 policy parameters. It's certainly there. Now, Mum, is it possible for me to refer back to the planning policy officer's comment on this specific appeal case?
There
was a reference to my colleague Ian Withington's
yes.
consultation response.
Yes, please do, yes.
I think it's fair and reasonable to report back to you today that this case took some considerable length of time to determine. The case went through different hands. We had 3 different case officers, resulting in me as assistant director, then head of planning, dealing with the case. That's exceptional. We were in a situation where a decision was required to be made here to enable this report to go forward. However, In drawing this report forward, I would confirm for you, Ma'am, that in reporting this matter, I did discuss at some length with colleagues across the service the issues surrounding the main material considerations. And although it may not be referenced directly in a consultation response, I can assure you that discussions were had with colleagues and that I did not dream up the issue of CT3. It is a significant matter for our service and consideration regarding the loss of community facilities within our district. As my colleague has said to you, we are a district with a pronounced elderly demographic. Elderly demographics do require provisions of care homes and resources such as that to enable our housing needs to be suitably met. So on that basis, I believe that it was right and proper, irrespective of the comments of the policy consultation at the time it was provided, for the council to report on matters of community facilities under the loss of a care provision. Thank you.
Thank you. No, I don't think we perhaps need to discuss that particular issue any further unless anyone has anything else to say. I think it simply now falls on me to take those views into account and reach some decision. So
sorry, there is one just small point on the interpretation. Yeah. Obviously, the definition is an important local facility, and you'll see we set out in our hearing statement how it was actually used. It was used as a specialist facility for disabled adults drawn from a wide area. So you'll no doubt have to think about that and whether it constituted a local facility in that sense.
Okay, happy to move on.
Well, I think I've just got Mr. Roson's hand up.
I'll defer to my colleague, Mark. Thank
you. Mr. Ashwell.
Well, I was just going to encourage you, I don't want to teach you how to do your job here, but I would encourage you to look at the use class of the existing building, not the precise nature of the use that it was put to, and the opportunities for reuse.
Well, I'm sorry, that would be, in my submission, an incorrect approach in law. You have to interpret the policy, and the policy talks about important local facilities. Something that's last used as an important local facility. So that is the important question for you.
I'm happy to move on to help you. I think
it was just to move on to that sort of the next part of that.
Yeah, I'm happy to do that. We could spend a lot of time on this point because we have over the last 18 months. So rather than bore you to death with that, I'll move on to the second point, which is setting aside our point on the fact that it's not applicable. We say that we comply with the policy as written in any event. So if you look at the policy, there are two limbs to it, two bullet points, and they're all bullet points as well. You don't have to satisfy both. It's one or the other. So the first point is alternative provision or equivalent or better quality. And that, we're told by Mr. Rowson, was the reason why the Bacton application was approved, because they had other care homes in the area. So taking that on board, Madam, and I won't read it out in detail, but from sort of 6.65 onwards in my statement, we set out the actual provision which this area can benefit from. And it's effectively, there are 9 care homes which are in play, with a further 2 coming forward through the process. Might actually have actually received planning permission now. So in terms of alternative provision, there is more than sufficient to meet the need. And the important thing is that they are all purpose-built facilities of approximately 66 bedroom sizes, which is effectively what the market is saying is the optimum size for care homes to come forward. And the market is clearly showing that that is the case. So small care homes like ours are no longer deemed viable. And again, Madam, we sought advice from a firm, and that's set out in 6.67 of my evidence. It was Hallmark Care Homes, and they set out the reasons why they felt our site was no longer a viable proposition. Firstly, the location. Secondly, that the accommodation was too small. And thirdly, the cost of refurbishing and getting it up to date would not make it viable.
Just so I'm clear, Hallmark, they're a provider, are they, of care homes?
That's right, correct.
Right. Okay, thank you.
So from the first limb, we say that is we clearly satisfy that requirement. And moving on quickly, because I can just finish this off quite quickly. The second limb is no reasonable prospects of retention in its current form, and will it remain as a commercial operation? Now, the council have suggested, or their economic development officer has suggested, because we haven't done a full viability test, whatever that would be, and a 12-month marketing campaign, whatever that would consist of, but we haven't satisfied this policy. Well, firstly, if we satisfy the first limb, we don't need to satisfy the second limb. But Madam, in any event, we have had advice from Thrive Architects, who are designers of care homes all around the country, and they did an assessment of the site against the various standards which are set out as a minimum requirement for all care homes, and that's set out in 6.63. And again, I won't read them out, Madam, I'll leave you to read those out, but clearly there are so many failings on the current site in terms of meeting those standards. There would be no viable option to deliver a care home within the existing fabric of the building. So I think on both limbs of CT3, we say that we satisfy the requirements, and the evidence is before you. The evidence was before the council, and other than the limited feedback we've had from Stuart Quick, the economic development officer, we haven't really had any consideration and assessment of that evidence is unsatisfactory, or more is required. We've sought that clarification, but it's never been forthcoming. So that's our position on CT3. Thank you.
Thank you. Okay, I'm going to invite the council to comment on those particular issues. I think I am I suppose the first point I really kind of want to address is the issue on what was said then, that there's sufficient provision to meet the need. And I think probably that as a starting point, if you wouldn't mind.
If I defer to my colleague, Mark Ashwell, please, Bob.
Thank you.
I noted that particular remark that was made there as reference to, I think, 9 other care homes and 2 that have secured. They have secured planning permission now. I can confirm that they are consented. In fact, one's under construction and the other site clearance work is going on. And then the remark was made that was more than sufficient to meet the need. And I don't know on what basis that remark is made. I've not seen any analysis of the need locally, which would lead to the appellant be able to reach such a conclusion. No quantitative or qualitative assessment about whether the existing facilities are adequate or inadequate in the context of a needs assessment. So just saying there's other care homes locally doesn't address the requirement.
Can I just stop you on that point and just go back to the appellant? I just want to offer them the opportunity to just comment on that if they wish to.
Thank you, Madam. I was going to jump in there. Clearly, the policy doesn't require that level of detail to be provided. Mr. Ashwell's policy CT3 just requires an alternative provision of equivalent or better quality is available. So it's just looking at the facility itself. And obviously in Bacton, there were 2 other care homes available, and it was felt that they satisfied CT3. There's no assessment in that committee report of need at all. We've never been asked to provide information on need at any stage from the council. And we would, if that was an important consideration, we would have looked at it. But the policy doesn't seek it, and nor have we been asked to provide it. So I think it's a little late in the day for Mr. Ashwell to add another tier of requirement when it's not actually justified. Just a very minor response. I was responding specifically to your question.
Sorry, yes.
Your question, which you're asking about other facilities locally, and the appellant's assertion that there was adequate accommodation to meet the need. That was expressly said by Mr. Armstrong, and I was responding to that. And just making the point that there is no evidence to support that comment that was put to you, that there's adequate supply locally to address the need.
Thank you. Mr. Rosen, you have your hand up. Do you wish to come in?
Thank you, Ma'am. The council obviously do assess matters of housing need through the development of our plan making process. We have done that in the emerging plan. I don't want to draw on empirical evidence today. That will be the addition of late evidence, which you are not welcoming, Ma'am. The position in our new local plan is that this specific issue has been significantly reviewed, and empirical evidence is available to support the assumptions drawn within the emerging plan policy. So the position taken with CT3 is an important one for this council strategically in terms of addressing its housing need. One minor point to reiterate, Ma'am, the decision at Bacton was a delegated decision. It was not subject to a development committee. I've explained the consideration around alternative provisions, and I would also add, Ma'am, that it would, in my view, be a lesser weighted decision than that given by a development committee after careful consideration of those reasons for refusal. Thank you.
I don't know whether the council wished to, there were other comments made in terms of the size, location of the care home no longer being viable. I'm conscious that these points have all been considered in the evidence, so I am mindful of that. There are submissions there, but if anyone did wish to respond to that, I don't think I've offered you the opportunity to.
I think, Ma'am, I would defer to my colleague, Mark Ashwell, on matters of policy in the first instance. I don't want to belabor this point. We've exchanged written evidence, but I think there is an opportunity for my colleague to explain why that consideration is in our current adopted policy and how it is being taken forward in the emerging plan.
I think more relevant to the point I think you were specifically asking. You're being asked to rely on the conclusions of a single operator that the building is unsuitable for subsequent reuse for much the same thing. You asked that question yourself about, who's the letter from? It's from an operator who runs care homes. And a comment was made that it was evident that it wouldn't be viable. And a remark that whatever a viability assessment might include, the facts are you haven't got any evidence about viability in front of you. Nobody's submitted a viability assessment. You're being asked to believe on the basis of Mr. Armstrong's sort of proposition that the reuse of the building is not viable. It hasn't been marketed in accordance with the policy. It hasn't been subject to detailed viability testing. Cases reliant entirely on a letter from a single operator suggesting that they'd have no interest in the building.
Anyone else wish to comment on that particular main issue of the agenda?
No, thank you. I think we've exhausted it, and it is set down in the evidence, so I'm happy to leave it there.
Thank you. Anybody else? Okay. The next item I have on the agenda is whether the council has an adequate 5-year housing land supply. And we have matters relating to the late evidence on nutrients that I need to address as well. I understand that, let me just get the right email in place. Okay, so the evidence that forms part of nutrient neutrality is very recent. In fact, the Natural England letter is dated the 16th of March last week. And the appellant has put together a letter of the 18th of March with their views. Now, we touched upon this matter briefly this morning, but I just wondered, obviously, the appellant wishes to adduce that this isn't a further impact on 5-year housing land supply. I wonder whether I could just revert to the council and see what their position is in responding to this particular evidence at this stage.
Thank you, Mom. In the first instance, I'll defer to my colleague, Mr. Ashwell, and then as required, I'll fill in behind that matter. Thank you.
Thank you.
I think our starting position would be, given the lateness of the arrival of this, literally on Thursday afternoon, as a new issue. We would favour an approach where you allow the hearing to close, adjourn, whatever the right process is, and allow for written submissions from the parties to consider that impact. I think we could have a useful debate today in the sort of hypothetical what are the implications of this if it is introduced, what would the impact of that be? But I personally would favour being able to make written representations on it. It's an issue which, as I say, literally arrived with us on Thursday. May or may not have wide-ranging implications for all sorts of issues in the district that we'd want to carefully consider. I don't know whether you're able to offer a view on that at all, as in terms of sort of process, really.
I think a lot of it falls on, it is late evidence. I think my primary question to you, Mr. Ashwell, is, are you in a position to deal with it today? Or do you need further time in which to deal with the content of what came in last week?
I don't feel I'm in a position personally. So the appellant is challenging the deliverability of some of the sites upon which the council relies to demonstrate a 5-year land supply, which may or may not be affected by the nutrient neutrality issue. I've not been able to go back into the case files, check the sort of planning histories on sites, precise state of play in relation to the sites that are referred to take a considered view and offer evidence to you today, which would allow you to make an informed decision. So, yeah, I feel ill prepared to directly address the consequences of the nutrient neutrality issue in terms of 5-year land supply, simply because it just landed on the desk, as I say, tail end of last week.
Okay. Can I invite the impellant in on this particular matter? Because I'm working on the comments that were made this morning, that you want this particular matter considered. And I think you commented that you wanted it dealt with within the hearing rather than written representations. Is that the correct recollection of what happened this morning, as far as you recall it as well?
Yes, madam, that's the appellant's position. What I don't at the moment understand is what exactly the nature of the council's difficulty is. I mean, in terms of the broader implications of sites being within the nutrient neutrality zone, of course, the council won't know just at the moment, because that's going to take quite a long time to play out. I don't think it's being suggested we should wait for written representations for months and months and months while the council works out all the implications of this. We put forward evidence on our experience elsewhere, and we have what the chief planner says. If what is being said is it's not yet clear which sites are in and which sites are outside of that zone, I have a bit more sympathy with that. And if that is what the council wants to provide further evidence on, then that might be something we would consider. But just in terms of the general, what is this going to mean? In my submission, part of our case is that the council won't know what it's going to mean. It's going to cause a great big delay while it's worked out what it's going to mean. So it wouldn't be appropriate to adjourn off for written submissions on that question.
So, Mr. Ashwell, I'll put that back to you. Is it the case that you're you have said you've not been able to go into the case files and have a look? Is it the case that you don't know which sites are in or out?
No, no. I've seen the maps of the zones. The zones cover, significant elements of North Norfolk district and the adjacent authorities, and taken at face value, the advice impacts on a number of pending decisions. What I can't tell you with any certainty is whether individual site proposals and those which are challenged by the appellant are impacted or not. Examples given of the West Raynham site. I don't know off the top of my head whether the West Raynham site drains into the Wensum via the Fakenham sewage treatment works, or whether it has got a self-contained private sewage system, as some of the other air bases do. And therefore the constraint on delivery, which is suggested by the appellant, is one that doesn't exist. I simply haven't had the opportunity to do that work. So all I'm asking for really is a period of time within which we can look at the additional contested sites, which have just been tabled very, very recently, take a considered view as to whether we agree with the appellant or not, and advise you accordingly. If you wanted to put a time frame on that, I think that would be reasonable. I understand the appellant's concerns about, this is a large issue which has, has been rumbling for years in other authorities up and down the country, and we shouldn't be delaying a decision for that period of time. But
how long a period of time would that take you to put together essentially your views on that?
Well, if the issue is constrained to the relatively small number of contested sites that have appeared very, very recently, then I'm talking weeks, not months. I mean, I don't want to be, absolutely definitive on this. It would be, unfair, I think, for the authority to turn around and say, we need to wait and see how, this is implemented. The site itself that we're talking about is not in one of the constraint areas, so it's not directly affected by the nutrient neutrality issue. So it is a decision the council should be able to make in relatively short order.
I think maybe I should have framed my question a little tighter than that. If I was minded to give you overnight to do that information, is that sufficiently long enough, or are you saying you need a couple of weeks, as you just said then? Is it something put together quickly, as quick as that, or? And I'm not pushing you either way. I'm just
no. I would like a couple of 2 weeks.
Okay, so
a reasonable period to give you a considered response.
Okay, I'm conscious Mr. Rosen has his hand up as well. I'll just invite him in just for his comments to start with. I think I have a way forwards on this, but I'll take Mr. Rosen's comments as well.
I'm always pleased to hear of a way forward, Mum. That's wonderful news. This letter arrived with me personally as the lead planning officer for North Norfolk on Thursday. The position we have is that the letter was also followed by a ministerial letter from the Department of Levelling Up, Housing and Communities also. Now, if I bear reference to that letter, the ministers are expecting the council to make representations within a matter of a couple of weeks or so. My timeline for returning to them is early April. This is a matter of paramount importance for our district. We don't seem to want to defer this in any way at all, but we do need to make sure that the responses we give you today are fair and reasonable across those contested sites. And I know of a number of those sites that have actually supplied HRAs and details that have been very carefully considered. And to strike them out as undeliverable at the strike of a pen within 24 hours today, I'm afraid, Mum, seems to me inherently unreasonable. I don't want to delay the estate's decision-making on this appeal, and I think a request for a fortnight's submission is entirely reasonable. We have a much wider remit than the appellants. We don't relate just simply to one site that isn't within the zone. We relate to a much wider district, and also we have an interrelationship across the catchment areas with our sister authorities. So it's really critical that we're not jumping the gun, that we are being consistent, we're giving careful consideration to the submissions of the applicants in other cases already, and that we're looking more broadly and strategically around this matter of housing land supply, which I believe is the way in which the guidance encourages us to think more. Thank you.
Okay, Ms. Parry, I think you were going to come in there, but
sorry, Madam. Did you want me to come in, or?
No, I think I'm minded to deal with it this way, unless anybody has any views, and I'm happy to listen to those. We have the original 5-year housing land supply position that we were going to discuss today, and I intend to go through that. Mr. Ashwell has said that he could have a discussion about the broader principles of nutrient neutrality today. I'm happy to do that. I'm conscious that I need to be fair and reasonable, and given the time that's elapsed and the position that's put the local authority in, I'm minded to give them longer to deal with that particular issue on nutrient neutrality. And I think rather than discuss that particular issue, those particular issues in detail in the hearing, I'm minded to allow the council to do that in writing after the hearing, with the view that I close the hearing tomorrow, that I invite the council to give their comments on the late evidence on nutrient neutrality, and then to allow the appellant the opportunity to comment on that. Once I've received those particular documents, I can then consider those, and if I need to reopen the hearing, I can obviously look at that, or alternatively, it may well be that I don't need to go down that avenue, depending on my findings on other matters. So, for instance, if I find this development is in accordance with the development plan, well, it really is not here. It's neither here nor there that I need to make a determination on 5-year housing land supply. The same with if I find that there is no 5-year housing land supply for the other reasons that you wish to draw to my mind, it really it may not need any additional hearing time if there are other matters that make a decision fall a certain way or not, as the case is. So I think that would be my view, that essentially I allow the council a couple of weeks for Mr. Ashwell to put his views together. I then allow you time, and I'm open to how long you need to be able to respond to that, and then at that point I can decide procedurally where I need to go with this. If I do need to reopen the hearing to hear evidence, or whether I can proceed to issue a decision at that point. Now, I'm happy to hear people's views on that. I'm conscious that I do want to give everybody a fair crack of the whip on this particular issue. It is late in the day, but is that approach convenient with the council? I can see some nodding heads.
That's inherently reasonable. Bear with me, Mel. We would be supportive of that, and I think that allows decision making to flow and be better informed and to be fairer. Right. And Ms. Parry, do you have any views on that? Is that?
Madam, we're content with that.
Thank you. I think that's probably the fairest way to go, to give everybody a fair opportunity to say what they need to say, and also to form those decisions. Obviously, Mr. Ashwell is being caught very much on the hoof with this at the moment. So with that in mind, if we proceed to deal with the 5-year housing land supply position on the matters that we were going to deal with, and we can leave the nutrient neutrality for those written representations in due course. Just as an aside, Ms. Parry, how long would you need to respond? Would you wish to have a 2-week period after the council have had their?
It would be much shorter than that. I would imagine a matter of days. I mean, could we say up to a week on the basis that we don't know exactly what the council are going to produce? I think I anticipate something shorter. I think so. And if on the back of what Mr. Ashwell writes, if you do need longer, then obviously do let me know via the case officer, and I'd look to accommodate that, because I want to give everybody a fair chance here. And so if we move on to 5-year housing and land supply as we were going to consider it, would be great.
Thanks. We've set out in our statement of common ground housing land supply. I suppose our initial sort of base point is that as we sit here today, we're at the end of sort of year 2 of the 5-year period, as was published in April 2020. So by any measure, the council's 5-year housing land supply statement is only looking for 3 years. But that's the latest evidence we have. So that's what we've looked at in this housing land supply statement. Sort of taking it line by line, if you like, in the table that we produced, beginning on page 3 of the housing land supply statement of common ground. Our initial discount is to the council's windfall allowance. Looking at housing land supply positions, it's common that windfall allowance is only taken account of in the final 2 years of that 5-year period, years 4 and 5. And the reason for that is that in the first 3 years, permissions will still be coming through that already have planning permission. So that's the reason that we say that.
Could you just repeat that? You just cut out slightly. You were just saying in the first 3 years, and then I lost track of what was being said.
Sorry, yes, of course. So for the first 3 years, it's normal that a windfall allowance isn't included to avoid double counting of existing permissions subject to a 3-year time period that are coming through the process. The council allows for an annual windfall allowance of 135 dwellings per annum for every year in the 5-year period, apart from the first year. So we've discounted that by years 2 and 3, giving a total of 270 dwellings to discount from the supply.
Okay. I think if we take these one at a time, I know it'll be a bit like a tennis match, but it saves confusion.
I was going to ask precisely that point. Can we go through it one at a time rather than go through the entirety of the chapter? So we entirely agree that there's a need to discount the windfall allowances moving forward. Just do that in different ways. Some discount first year, second year, third year. Norfolk District Council applies a 50% discount to the overall figure. So that's its starting point. We would normally expect to deliver 250, 260, maybe a bit more windfall plots year on year on year. So at the start of the process, we halve that number. That gets us to an annual figure of 135, and then we take off the first year. So essentially we heavily discount future windfall delivery using a different way to the way just described, but the effect is the same. It removes substantial amounts of likely windfall from the trajectory through a discounting process that adequately takes account of the double counting risk that was referred to. We've done that for the last 4 or 5 years. It's an issue that's been pursued through public inquiries and examinations routinely, and has been accepted on every occasion. That discounting principle is one that the council's not been on the receiving end of a bad appeal decision, put it that way.
I think
Yes.
from the appellant's perspective, we accept that that's the way the council go about it. We consider that a figure of 135, discounted as it has been, of an annual target of 487 dwellings per annum, it equates to about a third, 28%. It's still a very high figure in our experience. We would expect a windfall allowance to be sort of around 10%. And looking at the council's annual monitoring report, we note that there is a table in there, 2.15, where they look forward to a total windfall figure of 1,305 for the period 2020 to 36. That equates to an annual windfall figure of 82 dwellings per annum. That to us would be a more realistic figure than the one that is included in the council's current 5-year housing land supply.
Mr. Ashwell, did you wish to say anything?
I don't want to protract the discussion, but I'm just going to draw your attention to the detailed appendix in the back of the 5-year land supply statement, which explains the council's approach to windfall development and that discounting principle, and how we arrive at the 135 figure, and how we do that by not just looking backwards at historical delivery, but looking forwards at future supply pipelines and the types of development that would be delivered through windfall. So it's not just a backward-looking statistical exercise, forward-looking capacity exercise to arrive at a figure that can be genuinely delivered. But I'm happy to rely on the evidence that's published in the statement.
Thank you.
Are we okay to move on to the next site? That's land off Lee Road, Catfield. It's a site which is an allocated site in the site allocations DPD adopted in February 2011. The council's published 5-year housing land supply position was published in April 2020, and it anticipated this site to deliver 15 units in the final year of that 5-year period, year 24-25. We're now 23 months on from the date of that publication of that document, and we acknowledge that an application is with the council. It's an application that's under consideration, has been for some considerable time, but there's no planning permission. The ownership certificate of B has been completed, signaling that the applicant does not own the site, and I know that we're not sort of getting into the issue of nutrient neutrality. It is one of the sites which lies within that zone, and I note that there has been representations to the application, which I do allude to in the third column, which do relate to issues relating to impacts on the Broadlands SPA and the Broads SAC, which are within 0.9 kilometres of the development site. And those representations have been made by the Broads Authority and the council's own ecology officer, who are maintaining that they're yet to be satisfied that there won't be adverse impacts on those sites.
Mr. Ashwell, did you want to comment?
Not really want to add anything to the comments which are already in the council's comments in the statement. It's there. It's an allocated site. It's subject to a planning application. Very, very small scale. I wouldn't expect, multiple phases of development for years on the site once planning permission's been granted. It's a housing association proposal. I would expect rapid delivery on the site. That's the intention of the provider. You'll take a view as to whether that meets the realistic prospect of delivery, which is required in order to be included in the supply pipeline.
Thank you.
So yeah, moving on and just drawing on the needs as the NPPF states that they should only be considered deliverable if there's no detailed planning permission in place, if there's clear evidence that housing completions will begin within the first 5 years. And with that in mind, looking to the next site, which is land at Jubilee Lane, Cromer. This is another site which appears in the council's site allocations DPD, again adopted over 10 years ago. It's a very narrow site. The policy allocation talks about the constraints of the site being in very close proximity on one side to residential properties, but also in close proximity to industrial and employment uses. A site was the subject of a planning application, which is referenced in the schedule, that was made valid in February 2019 and with the council for 31 months, but subsequently withdrawn. There were some concerns around noise and interaction of residential with business uses, but ultimately that was withdrawn. And so, again, we're just saying that as we stand at the moment, there's no application into this site, and there's no clear evidence that it will deliver within this 5-year period. We've also made reference in the third column on the commentary to the latest evidence that we have to look to, which is the trajectory which was included in the Reg 19 local plan, and that's at Appendix B of our Statement of Common Ground, and that now doesn't anticipate this site delivering housing until the year 2027-28, so well beyond the 5-year period.
Thank you. Mr. Ashwell, do you have any comment on that particular one?
Only a broader point, because this will be a recurring theme, the reference to clear evidence being required to demonstrate deliverability. I accept that entirely. I would say the evidence which is relied upon is the submission of planning applications. They're publicly available, applications have been submitted, and the documents indicate an intent to deliver both on this site and on the previous site. Previous site is clear, I admit, because you've got a RSL provider there anxious to secure a permission and proceed. The circumstances behind this site is county council owned. I think they largely got frustrated with a lack of decision on the planning application, withdrew the planning application in favour of a marketing strategy, and the site is now actively being marketed. In fact, I think it goes to auction next month for residential development.
So it's actively being marketed without
by the county council. Without it's an allocated site. I mean, I can't. It'd be conjecture for me to say to you, why did the county council withdraw the planning application? I mean, I did conject that it might be because it took 19 months to reach a decision, reach a position where no decision has been made, and they decided they'd rather market the site and move it on to development. But I can't speak on behalf of the county council as their reasoning for withdrawing the application. The facts are it's county council owned, it's for sale, and it's an allocated site in the development plan.
I'm just looking at the table in the Statement of Common Ground on the council's position. I've got a -5, so I presume you're accepting that 5 can be withdrawn from the figure. Is that, am I reading the figure properly?
It reflects the difference between the site is allocated for 24, but the planning application proposed 19. So we adjusted the number to reflect what was proposed on the planning application rather than what was shown in the development plan. A subsequent application may propose more or less, but the -5 is the difference between the 19 applied for and the 24 that the site was allocated for.
And then, sorry, just going back to the one above at Lee Road, the +3.
Yeah, again, that's the same reasoning. The difference between what the site was allocated for and what the planning permission seeks. The planning permission seeks 3 more than the allocation policy suggested. So they're minor adjustments to the numbers to reflect the planning application numbers.
Sorry, thank you. Okay. Anyone else want to say anything on Jubilee? So land north of Rudham Style Lane.
Yes, Mark, this is a large site, outline planning permission for 950 homes. It was with the council for 4 years, 5 months from validation to decision being issued. It's an outline application with all matters apart from primary access reserved, and it's not just 950 homes, it's sort of like an urban extension with employment development, school, nursery, retail, new road network, etc. And reflective of that is the phased nature of the time limit permissions. It has phase 1 to come forward with reserve matters within 3 years, but then a longer time limit for later phases, with phase 2 reserve matters required within 5 years, and then phases 3 and 4 within a 12-year period. So it's it's expected to be lots of upfront infrastructure works required, 45 planning conditions to be discharged, and all reserve matters to be resolved, which in our submission is not going to be a quick process. We also note that the applicant isn't, it's not a housing developer, it's Trinity College, Cambridge. And no doubt they will be looking for a developer, I would imagine, to take the site from them or work in conjunction with them to deliver this site. I would just draw your attention to the final sentence in my column 3, where I'm afraid I've made a mistake in terms of referring you to the trajectory from the Regulation 19 draft local plan. The reason for that is that there's two sites north of Rudham Style, and I should have made reference to the site which appears in the first line on page 266, that trajectory, and that's the latest sort of publication by the council on this site, and on that basis they expect that this site would deliver 10 dwellings in the final year of the 5-year period, 2024-25. For the reasons that we stated, we don't believe that to be the case, and we've taken all 150 from the projected supply.
Mr. Ashwell?
I'm just going to add two comments to the written submissions, which I think have happened since I produced the statement. First is that Trinity College have now marketed the site, so it's formally available by tender, either as in lots or as a whole, so it is available. And the second point in terms of infrastructure delivery is that North Norfolk District Council is funding and delivering the major road infrastructure, the roundabout into the site. as a measure to improve deliverability and de-risk that upfront investment. So we'll be funding those roadworks. And those two things are not reflected in my comments there.
And just in terms of funding that infrastructure work, is that subject to grant funding? And
no. North Norfolk District Council has essentially done I'm going to call it a deal. That sounds like it's a dirty deal. We're offering to fund those works in exchange for an increase in the affordable housing provision on the site. So there's sort of improve the sort of viability of the scheme by funding those early works in exchange for a percentage increase in the affordable housing delivery as the development proceeds. And that's, so I understand it, that's an NDC funded proposal. It's not dependent on external grant funding.
That's entirely correct, Mark. That's exactly where we stand. I've sat in those.
Yeah, doesn't involve any other parties. It's us. Those works are due to be on site this November, outside of the holiday season, when they won't cause traffic chaos.
So just in terms of on the table, the appellant's suggesting removing the whole of the 150. I've got then in the council's column, I've got a -50. Is that?
Yes. So we think it's still reasonable in the remaining 3 years of the accounting period that we're talking about, 3 years to allow for the submission and determination of reserved matters and commencement and completion of 50 units on the site over a 3-year period. Seems reasonable. The outline application described as, straight outline with just access, it's supported by a development brief and a detailed design coding process, which would resolve many of the issues around sort of the reserve matters that you would normally expect to get involved with. So we don't think it's unrealistic to conclude that reserve matters commencement and delivery on site over a 3-year period. A site which has admittedly taken a long time to get to this stage, but the fact that the site is now marketed to us indicates a willingness to bring the site forward.
Madam, the council aren't saying 50 homes are going to come forward in 3 years. They're saying 100 homes are going to come forward within the next 3 years.
Sorry, my mistake. Yeah.
And Madam, I just want you to reflect on whether that's even slightly realistic, given we don't even have a single reserve matters application.
Okay. Did anyone else wish to say anything on Rudham style? Should we move on to the next one? Hang on, Mr. Rowson's.
Just very quickly, sorry, Mom, I'm a little slow on my buttons today. In terms of speed of delivery, Mom, the council are funding significant amounts of infrastructure here. It is reasonable to then expect that as a corporate priority that we will be looking to receive and determine reserve matters applications at pace to ensure that affordable homes delivery is going to happen. We're investing hundreds of thousands of pounds in the site. It will become a corporate priority to move these applications on. Thank you.
Sorry, Madam, can I just jump in here? We're getting lots of assertions from the council about what might happen. None of this was written in this statement, which was only completed a few weeks ago. There's no evidence being put in front of you. It's all ifs and buts and maybes. And I think you've got to make a decision on the facts and the information in front of you. So I would just like to say, are we going to get more of this on every single site going forward? Or should we just rely on the evidence which is before you, which we thought we'd agreed? We were accused of putting new evidence in. Well, Mr. Ashwell and Mr. Rowston are adding new stuff all the time on every site. And we don't have an opportunity to comment or see any evidence on this. So we've got to be fair on this, Madam.
Yes, well, I'm inviting you to comment on it. And obviously, I am mindful that I am being assured these things, but ultimately, I'm also mindful of the evidence before me as well. So I'd welcome your comments. I welcome the council's comments on it, but ultimately I will have regard to what the level of evidence is on these matters when I reach my decisions on 5-year housing supply on these individual sites.
Thank you very much.
RAF West Raynham.
I think we're in agreement on the next two sites, aren't we?
So that agreement, though, both of those figures are removed entirely from the 5-year position. Is that right? So that's.
Well, Madam, you'll have seen in relation to RAF West Raynham, we're agreed that 24 come out, but in light of the nutrient neutrality, the council now say, well, 94 come out, but you'll have separate.
Yes.
Submissions on that.
Does that same position, Ms. Parry, apply to the next site as well on nutrient neutrality?
That's taken out in its entirety, and that's agreed by the council.
Right.
I think that's an agreed position.
Okay. Stalham Hopkin Homes or Stalham?
Yes, thank you, Ron. So we basically looked at the published evidence of face value that subject to an application for 30 dwellings. The council's position is that that should be increased by 71 on the strength of 2 new applications that don't appear in their trajectory for 2 separate applications for 61 flats and 40 affordable dwellings. We don't really agree that that's a valid approach. We think the council should have updated their housing land supply trajectory. But nevertheless, we have looked at the 2 new applications, and we have significant concerns that these are contrary to the policy allocation for the site. Policy ST1 of the site allocations DPD requires a minimum of 2 hectares of land for employment. This was something that was permitted in outline with the Hopkins Home Scheme, but it seems that Hopkins Homes have delivered the housing, but now that part of the site which was to provide the employment provision is now the subject of these 2 separate applications for housing. As a consequence, the application is the subject of what appear to be quite strenuous objections from local councillors, from the town council, from the local business forum. So on our submission, there's no clear evidence that this will deliver within the 5-year period. And we note again the council's latest position on this, as published in the Reg 19 draft local plan, that the site would deliver 10 homes in the final year, 24-25, but our position is this is optimistic for the reasons that we've outlined.
Sorry, how many did it say in the Reg 19 that it deliver in 24-25?
10 homes.
10, thank you. Mr. Ashwell, could you enlighten us on that one?
Yeah, I'm reluctant to move the goalposts again here and rely on stuff that's not in our evidence bundle. But, the facts are that the site got planning permission last Thursday at the development committee for the 101 units, which are now included.
Sorry, how many units was that?
101.
101 units.
That's why there's a difference between the 30 and the figure that we've put in. And that's a full permission.
And that full permission, is there any legal agreement that goes with that? Anything that's Is it
Yes,
issued?
yeah. So I say the resolution was to grant permission, so there will be a Section 106 agreement to complete. I'm not suggesting that the decision notice has left the building. It hasn't, but the resolution is to approve. So that, the policy issues which were referred to by the appellant about, employment uses on the site and concerns about it have been considered by the development committee, and they've resolved to grant permission.
Just in terms of turning round legal agreements, how can you give any time frame as to how long that will take?
I'm going to look to Mr. Rolson here if he can offer any enlighten us. I'm not actually sure what the content of the legal agreements are, whether it's standard clauses in relation to affordable housing provision or whether there's anything more significant in there. But I think there would have been heads of terms and there would have been a debate about it at the committee. So, but I wasn't part.
I can take you a little further along that line, Ma'am. Again, this is at your request for this information, not as submitting the information in another way. The position is that the Section 106 is significantly advanced. The developer is working towards a grant funding horizon, and so needs to be seeing this Section 106 completed. We're working with them to deliver important affordable homes and extra care units in this part of the district.
Did the appellant's team wish to come back on that?
Yes, Madam, we've heard what the council have said about the grant of planning permission. In light of that, we would withdraw our objection to the 30 units that were originally in the supply. So we would accept that those 30 units, because it's now a category A site effectively, we would accept it's reasonable to expect those 30 units to come forwards. What we do maintain an objection to is seeking to add 71 units into the supply. Madam, I'm sure you've come across this point before. It's quite frequently argued in inquiries, but effectively a local authority shouldn't be allowed to add to their housing land supply, particularly some 2 years after it's published, because then they haven't gone through and made all of the other adjustments one would need to make when redoing the housing land supply. So it is entirely inappropriate some 2 years down the line to try to add this extra permission, this extra 70 units in, and unless those additional 71 units go in, then the council don't have a 5-year housing land supply on my calculation.
I don't know whether anyone's able to do this calculation right now, but if those 30 units do go back in, which is what the appellant is accepting can happen, where does that leave the 5-year housing land supply?
I don't think it's possible to do that because it depends on the view you take on the other elements of the supply and whether they're in or not. I think the gap is in the evidence. I think it's 78 dwellings, and you will either include or discount various aspects of the supply. The figure is somebody will nod their head on the appellant's table here. I think if you remove 78 dwellings at that point, the council doesn't have a 5-year land supply position. I'm doing that from memory.
Mm-hmm. So yes, you're right. It is 78, not the 71 I said. So if you don't put the 71 units in, then the council have a housing land supply of 6 dwellings.
Right. Thank you.
If you don't accept anything else we say.
Yeah.
I've just been very helpfully told that that turns the appellant's approach, accepting those 30 units, into 3.88 years supply.
Thank you. I'm grateful. Does that cover everything on all of those sites, or does anyone else wish to say anything? If anyone else,
nothing further from us. Thank you.
Does anyone wish to say anything further on 5-year housing land supply? If you wish to sort of cover the broad brush part of the nutrient neutrality arguments, I'm happy to hear that. Alternatively, I have got what the appellant has said. I've got your letter with the enclosures. I'm happy to deal with it either way. Did you have any view on that?
Well, Madam, it's probably just worth, so that the council hear what we have to say and so they know what to respond to in their written evidence. Madam, the appellant's position is, and I'll be told I'm wrong, I think all but one of the sites we've been discussing today are, we believe, affected by the nutrient neutrality. All but the Chroma site is, on our understanding, within the nutrient neutrality zone. So all of those sites, in order to come forward, whether it's initial application stage or reserve matter stage, are going to have to demonstrate nutrient neutrality before a permission can be granted. And as we set out in our letter, and as is made clear from the Dear Chief Planning Officer's letter, that is not something which can be done overnight. That is going to take a substantial amount of time for those developers to be in a position to demonstrate it, because all the systems are going to have to be put in place in North Norfolk. And that is frankly reflected in the Dear Chief Planning Officer's letter by the comment about the impact it's inevitably going to have on housing land supply. You can obviously hear from my colleagues, if you want to, about their experience elsewhere, but it's effectively stopped any housing development coming forwards in large swathes of the country. And those are areas which are much further advanced in the North Norfolk in terms of putting the procedures in place to deal with nutrient neutrality.
We've had experience across the country, notably Wiltshire and Horsham at the moment, and it's a very significant pause and delay on development, because there's either a bespoke solution for individual sites as they come forward, generally only suitable for smaller sites, or the alternative is sort of an overarching strategic solution with getting disparate sort of bodies together, like the Environment Agency, Natural England, bodies that are already stretched, I think, to put it mildly, to come up with a strategy that sort of fits all, and that is a very lengthy process, unfortunately.
Just to give you a flavour, Madam, the Somerset have had this problem for 2 years, if not a bit longer, and their first guidance from the County Council came out last week. So it's taken them 2 years to come up with guidance. That then has to go to the local authorities to be made into an SPD, and then that has to be voted on and actioned. Plus Natural England have to be involved because they have their own particular requirements. So they've had a 2-year head start, and they're basically, they're not allowing sites to come forward unless they are, as Mr. Welshman said, large sites and can deliver potentially their own mitigation, but they have to be signed off by Natural England. Natural England don't have a template to sign them off yet. So without sort of overestimating it, it's a significant delay. And I think when the council actually go back to their desks or their bedrooms and think about it, I'm afraid Mr. Ashwell is going to have to reach the conclusion that he doesn't have a 5-year supply, despite trying desperately hard to cling on to it. But that's no insult to him, because there are lots of other parts of the country who have had this problem and have had to grapple with it. Yeah. So I think it's an inevitability, but I appreciate Mr. Ashwell wants to have a think about it before he confirms it.
I don't take it as an insult, Jeff. I'm just think it's, it's a big issue. It's significant, has major consequences across the district. We're just asking for a reasonable amount of time to consider it and respond accordingly. It's not a delaying tactic. We do treat it seriously. I'm not offended by working in my bedroom.
We all do that.
Yeah.
I can see Mr. Rowson's hand is up as well. Did you wish to come in on that point?
Yes, please, ma'am. This is an issue which is now affecting more and more local planning authorities. It is very clear to me that the Department for Levelling Up Housing and Communities must take this issue very seriously when they're considering matters of housing, land supply and delivery. It is unreasonable to expect councils to continue delivering housing when they're in a situation where there could be a significant strike across the land within their districts that is capable of delivering housing. We can't have our cake and eat it. If we have to develop nutrient neutrality plans across the breadth of this district, we cannot continue to deliver housing supply. So on that basis, ma'am, the position is pretty clear to me. It has to be a situation where councils will not be able to meet those tests if we take this in its baldest example as explained by the appellant. What we must then do is consider the council's position in terms of the wider parts of our district. So nutrient neutrality does not mean that we immediately grant planning permissions elsewhere in our district. What it does mean is that we consider our position against the broad swathe of planning policies within the National Planning Policy Framework. It still means that we have a planning policy framework for decision making. And that's what you're hearing today, Mel. Thank you.
Mr. Ashwell, your hand's still up. Is that a legacy hand or did you?
Well, you sort of invited further submissions on 5-year land supply, and I didn't know whether you wanted to go on beyond the challenge sites and the consequences of council's ability to show or not show a 5-year land supply on how you would make a decision, and whether you were going to have a discussion about that or whether you were content just to take your own view in relation to those matters.
Well, Madam, for our part, we were anticipating discussing the consequences of having a 5-year housing land supply or not in the final part of your agenda where we deal with planning balance. It doesn't seem to us that you need to have already dealt with nutrient neutrality. It's a straightforward application of the NPPF policies.
Is that?
Okay? Yeah, that's fine.
Okay. With that in mind, is there anything else anyone wants to discuss, or shall we move on to that last bullet point? No? Okay. Well, let's move on to that last bullet point then, because it flows nicely into it. Ms. Parry, did you want to address me on those particular matters?
Well, Madam, my colleagues will obviously address you on the question of the weight to be put on the various material considerations, but just to make sure that we start off on the right foot in terms of the 5-year housing land supply point, I think it's been suggested in discussions outside of the hearing from the council that the fact that this site is in the Aomb in some way means that the tilted balance can't apply in this case, regardless of whether there's a 5-year housing land supply. I just want to make it clear, if that is what their case is, it is wrong. Madam, I'm sure you're familiar with the case in Monkhill in the Court of Appeal, which dealt specifically with these points. Essentially, harm to the Aomb can give rise to a clear reason disapplying the tilted balance. But in order to reach that view, you would have to first of all decide there was harm to the Aomb, and then you would have to balance the benefits of the scheme against that harm. And only if you concluded that the harm to the Aomb outweighed the benefits of the scheme would there be a clear reason for refusing planning permission so as to disapply the tilted balance. So the headline point is that if there's no 5-year housing land supply, we say the tilted balance is applicable.
Madam, just to turn to the planning balance, we actually set that out in the statement on page 36, 6.75 onwards. So rather than repeat it, it is all set out there for you. But clearly, we are saying that the delivery of houses, delivery of high quality houses, a scheme which delivers sustainable benefits, much higher credentials than most homes have been delivered in the area. It is all of a significant weight for your consideration. We were obviously saying that in terms of the overall policies, we comply with those policies. So in terms of being compliant with the development plan, we say we are, and that these other benefits then are to be considered in the planning balance, in addition to being in compliance with the plan. as I said, set out there in more detail rather than just repeat it again.
Thank you. Do the council wish to say anything on the planning balance?
Just to confirm the point that was made, and it was my error in a discussion over the phone that the Aomb acted as some sort of automatic barring of the application of paragraph 11D. That's clearly not the case. What you have to do is to consider the provisions of the framework as taken as a whole in the way that it was described to you. We would be content, or we would say that the policies are aligned with the NPPF, and the issues which are in play here about the unsustainable location, the loss of community facilities and the harms to the Aomb are the same whether you assess those proposals against the provisions of the NPPF or whether you assess them against the provisions of the adopted policies of the core strategy. The issues remain the same, and the way that you consider those proposals will be the same. If you find that there's harm, and that's supported by the NPPF, if you find that the loss of community facilities is an important consideration, again, that's supported by the NPPF. These things are not made up. The NPPF isn't silent about them. And if you find that the location is an unsustainable location for housing growth, that is also compliant with the NPPF. That conclusion would be one that you could reach. So we don't think the absence of a 5-year land supply is that pivotal to the decision. You'd still have to consider the same issues and reach a judgment accordingly.
Thank you. Anyone wish to say anything else? No. Moving on to other matters. Yeah.
Yes.
I had one bullet point on there about biodiversity, but that's fallen away, so we don't need any discussion on that as far as I'm aware. Conditions and planning obligations. I have a copy of the unilateral undertaking. It's signed, it's dated, and it seeks to secure that RAMS payment and the bicycle provision voucher. I don't think I needed to ask anything about that. It seemed fairly straightforward, unless anyone wants to draw anything to my attention. If we move on to then conditions. Now, give me whilst I look for the original version. I'd normally go through these one at a time, but I think that they're fairly straightforward, and I didn't really have a great deal of comment on them. I obviously know that they've been agreed by the parties as well, so that's helpful. The only point I had to raise on condition 4 about land contamination was, I suppose, my query whether that should be a pre-commencement conditioning and incorporate the demolition, really. But it was just a sort of a talking point, really, to see what people's views were on that. Obviously, the way it's worded, it's not pre-commencement, and it specifically excludes demolition of those existing buildings. But
Madam, we're content with that suggestion, and we would be content to write with our written consent to that being a pre-commencement condition.
I don't know whether the council, obviously the council said that.
Thank you, Mama. Precedent condition would fit well and include that demolition. We would have no objection and support that change.
Condition 5 is pre-commencement, isn't it? Obviously, pre-commencement decisions require the permission of the appellant, essentially the applicant, to that they're happy with that being pre-commencement conditions. So just to be aware that that permission has to be in writing. It may well be that I have to seek that clarification in writing as well. But obviously, I've got today's clarification that you're happy with that being a pre-commencement condition.
Madam, can I just interrupt briefly on 6 on electrical vehicle charging? Yeah. Clearly, you heard from Mr. Morgan earlier that there is a list of other sustainable measures which we're offering.
Mm-hmm.
And they're set out on page 26, 6.32 of the planning evidence. If you feel that they are important considerations for your processing of the appeal, we'd be happy for those to be included within that condition. I mean, not all of them, but some of them are statements rather than necessarily objectives. But I think if you read through them, you'll be able to understand which are the ones which, so for instance, the air source heat pumps we talked about earlier.
Yes.
That might be something you want to be secured as well. Thank you.
Thank you. I had a query over the travel plan, and just it refers to an interim travel plan and then a full travel plan. I suppose my query was why it couldn't be a full travel plan, why it needs an interim one on such a small site, but wondered if someone could fill me in on that one a little bit.
From the council's perspective, Mum, I'd be perfectly happy with the single travel plan.
Would that be with the appellant?
Yes.
And equally, there's some reference within that particular petition to approved modifications, and obviously it's within my remit if I'm minded to grant planning permission and draft the conditions that I might think with them a little bit. But
the council may have been getting away with itself there, Mum. We may be thinking of 950 dwellings in Fake.
It just didn't seem particularly precise, that. So okay. Condition 16, I just had some concerns about it being prior to the first occupation, when it refers to the existing trees, and whether that should be that landscape plan should be available sort of before then, or whether perhaps I'm being too protective.
So is it the final bit of that?
No, I think no. My concern was it obviously it refers to plans showing trees to be removed and those details being approved by the council, but that plan being prior to first. I think I've just lost someone at the meeting, but that plan being available and submitted prior to the first occupation. I just wondered whether it needed to be sooner than that.
Yes.
It doesn't actually, I think, have a trigger for when you have to put the plan in. So the plan has to be implemented prior to first occupation. But the first bit, normally you would have a point by which the plan should be put in and approved. So I think that's what's missing from the condition.
I think it is, isn't it? But I presume no one.
Yes, it could be, because we don't usually ask for landscape conditions to be prior to commencement. So it's about trying to get that middle ground where possible, really. Yeah.
Oh, what about it if it was the sort of the provision of the details?
Yeah.
No, I suppose it's the trigger for that, isn't it? It's sort of no development above ground, slab level, or so that it's not, or does it be a pre-commencement condition, because I don't want to be in that situation where development, the site's been cleared, I suppose, and as all the
and those trees to be retained have gone. Yes.
Yeah.
Not that there are any, but yeah.
Right. Am I just being a little? I'll have a think about that one anyway.
Okay. Yeah.
Condition 20. I've just underlined installation. I think it probably needs to just be maybe no development above slab level until those details.
That's agreed.
There's a commonality of wording there, Mum, that would fit across a number of these conditions, isn't there? Yeah.
There is. Condition 22. I've just scribbled, maybe it should be all external materials.
Given the discussions today, Mum, with regard to the sensitivity of those materials, yes, I think I would be minded to agree.
And then on the back of that, it might well be the case that 23 then sits better within 22, and that's perhaps just a duplication.
Yeah, a single condition would work there.
Yes, happy with that.
Okay, that's all I really had to say on conditions. Does anyone wish to add anything else?
Nothing further on behalf of the council, Mark.
Did I see somewhere there was a reference to a condition being sought that it shouldn't be for holiday occupation?
I think that was the parish council requested that as a condition, and we put a response to that in our submissions.
Okay.
I would just add, if I can, Ma'am, that one of our members, the local ward member, Councillor Holliday, was very supportive of the parish's position with regard to that particular comment, and also the comments relating to linkage and footpaths. But clearly, she's just simply stood behind her written statement that you have already.
Right, thank you. Okay, I think that's everything on conditions, unless anyone wants to add anything. Cost applications? Any?
That's none, no.
Okay, so I think with me. Site visit arrangements. We look like we're going to finish today and not need tomorrow, but I have provisionally set aside time on Thursday to visit. I think that's what we'd all agreed. So I'll leave that as the day that I am going to visit the site. I propose to do it as an unaccompanied site visit, unless anyone has any strong views to the contrary.
No, we're quite content with that.
Thank you. And I presume that you're happy for me to wander freely about the site. Are there any health and safety concerns I need to worry about? Obviously, I'll have a sturdy pair of shoes on.
Madam, we're going to open the building should you want to go in.
Right.
Just bear in mind it has been not used for about 5 years, so it still has some items from previous occupation in, but there's no fundamental health and safety concerns.
Lovely, thank you. And the wider site, I presume that's accessible, is it, if it's a little overgrown?
Indeed, yes. And so I'm sure you're aware that if you wanted to go round towards the railway line, that's all estate land, and you're able to do that if you want to.
Lovely, thank you. But presumably not cross the railway line, is that?
I don't know what's across. I don't know whether we're on the other side of the railway line. Right. It's woodland, I'm told. So.
Okay, thank you. Mr. Rowson, I thought you were going to say something then. I thought
just one point, we would be grateful if you could look at the the building internally, but within reason, of course, Mum. We
Yes.
wouldn't want you to put yourself at risk.
No, that's fine.
The other issue, as you've heard from our team today, are those views from the garden centre car park, but that's public domain, so it's easily accessible.
Right, thank you. I have those other locations that we noted this morning where I was asked to view from, so I'll make sure that I view from there as well. Just in terms of going inside the building, is it sufficiently well lit? Do I need a torch, basically?
No, what time are you thinking of going, roughly? Because that was the thing I was going to ask. It'll need to be unlocked. The site and the building will need to be unlocked for you to go around.
I'll be there no sooner than 11:30, so probably nearer to 12 in fairness.
There'll be plenty of light for you to see all around. You don't need.
Lovely. I just wondered whether the windows were boarded up. I didn't want to crawl around in the dark.
The sun is shining in North Norfolk, Mum, but not that strong.
Good. So yes, so if I just attend on my own, obviously nobody else is attending. I'll attend on Thursday, have details of where to view the site from. I think that covers all matters. So it seems to me, unless anyone wishes to raise anything at all on anything we've discussed or anything we've not discussed, if there's anything anyone wants to put forward at this stage, then please feel free to do so. Obviously, I will have regard to all of the written evidence before me in making my decision on what we've discussed today. Anybody wish to speak? No? Okay. So it seems to me we've covered all the necessary matters and completed the discussion. So I will shortly close the hearing with a view to attending at the site on Thursday. I am obviously inviting the council to respond in writing to the matters that the appellant has raised within their letter of the, I'll just check the date, I think it was the 18th of March. And I would ask that be done within 2 weeks. So let me give some time frames out so that there can be no confusion. So if the council could provide their response by the 6th of April.
Agreed, Mum.
That's okay. Nobody's
that will be at the latest, Mum. If we can give you the response sooner, we will.
That would be lovely if you could. And then bearing in mind that time frame, if I suggest by the 13th, no later than the 13th of April, for the appellant to give their comments on the council's evidence. Does that sit well with everybody? And as I said, if that week isn't long enough, then do please let me know. So in light of that, just have to thank you for all of your contributions today. It's been very helpful. I'm very grateful, and thank you for your patience in putting up with me trying to get technology sorted. At this moment,
just before you close, we were just wondering if you had an anticipated timetable for a decision, or
I don't, I'm afraid. I will obviously do it as soon as I'm able to do so. Obviously, it will be delayed pending the outcome of the nutrient neutrality matter. Yes, I think that's probably as much as I can give you. But as I said, thank you for all of your contributions. It's been very helpful. The hearing is now closed. Thank you.
Thank you.
Thank you, Mel.
Thanks.
Good day.